Any mention?
Please, Your Lordship. Your Lordship, I am praying for adjournment of the case number 28 of the hearing list, Your Lordship.
Yes.
Lordship, I'm for respondent 1. We are a formal party, Lordship, in this
I
matter.
have taken consent of Mr. S. N. Nehu.
Yes, 2 weeks.
Lordship, I beg to mention item number 21, Lordship. Lordship, I pray if this matter can come up after 2 weeks.
21.
21, Lordship.
No objection.
No, I
Oh, yeah, there.
No.
Highly obliged, Lordship.
May please, Lordship. Lordship, I beg to mention item number 24 and 29, Lordship. I have mentioned, I have informed to the
Doesn't
government.
matter. Why you want adjournment?
I have some personal difficulties, my lord, today.
You never adjourn cases, now you started adjourning.
No,
Then all hope is lost for High Court of Meghalaya. Yes.
Lordship, item number
First
23.
Lordship.
23, Your Lordship.
Yes?
Item number 23, Your Lordship. Come next week, Your Lordship.
Your father?
I'm for a petition.
1 week.
Much obliged.
May I please, Your Lordship? I beg to mention item number 19, Your Lordship. I pray 1 week time, Your Lordship.
No objection, Your Lordship.
Yes.
Obliged.
May it please, Your Lordship, I crave leave of Your Lordship, item number 14 and 17. If this matter may be listed after a week, Your Lordship.
Revision of a Home Guards Lordship. That Home Guards Lordship, that matter was heard with the revision.
No urgency.
There is urgency.
Matters not even heard. What do you have to come some instructions?
Only 1 week, Your Lordship.
What instructions did you come
Because,
with?
they have been disengaged. So, for that reason, I just wanted to take instruction of only 1 week will do, Your Lordship.
But you know that you've been disengaged since you've been disengaged a long time before you came to court, correct?
No, Lordship, no.
Why the matter?
While the matter for revision was pending, Lordship, here I pray for that the benefit of the Fifth Pay Commission was not.
Yes, I remember.
While the matter was pending, then only they have disengaged me. So now the matter was tagged together. So far as
There's no interim orders.
No, there's no
Lordship,
interim
no.
order, Your
Why you didn't move?
I moved, Lordship.
No need now. Too late. 2 weeks, yes.
No, I have moved.
Highly obliged, Your
Lordship.
I prayed for interim, Lordship, but the court has declined.
This matter is listed after 1 week. We finish it off.
Then item number 22, Lordship.
20?
22, Lordship. This one. After 2 weeks, Lordship.
No objection.
Yes.
All right.
Obliged.
Supplementary list. Item number 1.
May I please, Your Lordship?
Yes.
These are all VC matters, Lordship. I am the job card holders of my Lord, Feshak and the VC, my Lord. And the VC has expired on my Lord 12/2/2024. Until date, no VC, elected VC is constituted, my Lord. No election is declared, my Lord. So the Deputy Commissioner had issued the direction, my Lord, at Annexure 3.
Why? Which district is this?
West Karo Hills, my Lord. At Annexure 17, my Lord.
Lecture 17?
Annexure 3, page 17, my Lord. My Lord. May I read, my Lord?
No, let's see.
Yes, my Lord. And
This is dated 20 September.
uh,
Why no elections? What's the reason?
my Lord, the
Politics and
respondents has,
fighting.
my Lord, clearly answered
You
on
take
that
notice.
issue, my Lord.
My Lord.
But Mr. S.K. Hassan issued notice. Mr. Argurum is present except on behalf of
1 to 5.
1 to 5 no further call for. Just after 2 weeks.
My Lord, 1 to 5
1 to 5 are connected
matter, only
item.
the village different place, my Lord.
Yes, sir.
Highly
1
obliged.
to 5 no further call for. Just after 2 weeks for instructions affidavit.
Highly obliged.
Just took affidavit.
Item number 6.
My Lord, this matter relating to appointment of the assistant teacher in the deficit school.
SSA teacher.
Deficit school, my Lord.
Yes.
Deficit school. My Lord, the advertisement was issued by the SMC and the writ petitioner applied along with all his documents. and he was selected. An appointment was offered to him, and he joined the service. Thereafter, the SMC forwarded his appointment to the STSO for approval. Now, STSO has rejected his appointment, saying that he is 18 months DLET. Though, in fact, petitioner is a regular 2 years.
Regular course. 2 years?
Yes.
He's not 18 months.
He's not 18 months. May I just take
Where have you said that?
My Lord, may I just take a few annexure. Lordship, may kindly come to page number 21 of my annexure.
Yes.
This is the 2 years DLET course through NIOS. And thereafter, my Lord, advertisement, MTech is page number 22. MTech certificate.
Yes.
Thereafter, my Lord, the advertisement may come to page number 25. Was issued.
It's page annexure 2.
My Lord. And annexure 3 is the advertisement,
Annexure
which
3.
mentioned 2 years DLET.
Yes.
Yes. And now
2
he
years
fulfilled both. He fulfilled both. Now he applied and he was selected first. And
Where is
therefore, page number 26, appointment letter was issued to
Yes.
him. Page number 26. On 2nd June 2024, asked him to join for service.
Yes.
And the next page number 27, he joined immediately. And
This was he appointed 11 June.
yes, just last month only. Last month only.
Yes.
My Lord. He joined immediately, and thereafter
He joined on
my
18
Lord.
June.
Yes,
Okay.
my Lord. And thereafter, my Lord, page number 29. The STSU has issued this impugned order. May I read, my Lord? On the above subject, I am to inform you that the
Where's
approval.
annexure 6?
My Lord, annexure 7, made.
What's annexure 6?
Annexure 6, my Lord, I put up when I served in the school, the MC informed him that I cannot continue the service. Therefore, he put up this application seeking for a copy of the impugned order passed by STSU.
Okay.
And STSU copy is, my Lord, page number 29. My Lord, may I just read out the relevant portion? On the above mentioned subject, I am to inform you that the approval for the appointment of the newly recruited teacher at such and such is hereby rejected due to the recent judgment and order of the Honorable Supreme Court dated such and such in the case of Janvir Singh versus State of Uttarakhand and others, that 18 months DLED diploma course holder under NIOS are not eligible for appointment in lower primary schools. This is for favor of your kind information necessary action. Absolutely is correct, my Lord. In Janvir Singh case, my Lord, in Uttarakhand, those who obtained 18 months, they applied. And the matter reached to Supreme Court. Supreme Court held that, my Lord, I have annexed that judgment also. Supreme Court held that 18 months is only one window opportunity for the in-service, those who are in service.
Not for fresh candidates.
Yes. So it is not equivalent to the 2 years. 2 years diploma. 2 years diploma. That judgment, my Lord, the next page.
That's all right. Now, why then how have they said that you don't have 2 years?
My Lord, here they say the STSO read my.
On what finding? On what basis have they said that? If you have a certificate saying that you're 2 years, correct?
Yes.
Then why they said 18 months?
My Lord, therefore the SEO, why he read that my document in this way. All the documents are there with the SMC, and FCC is supposed to forward all the documents.
You all been terminated.
Already terminated. Because
Yes.
I'll take instructions, Your Lordship. There seems
Yes,
to be
I'll
some
take them.
in the
discrepancy.
meantime, Lordship, some protection in pure order may be stated.
We can restore it, doesn't matter.
My Lord,
Once
they
it
say say that SMC is directed with the SCSO to go for fresh advertisement.
Okay, yes.
Because of that, my Lord.
Where's the direction? Where's that direction from the SCSU for?
My Lord, it is not mentioned, but orally informed the SCSO, the SMC.
Can we pass orders on basis of?
My Lord, I have made a specific amendment.
So
Lordship
where is
permits me. My
Where
Lord,
is
may I
that?
just take a Lordship amendment. My Lord.
Your Lordship, here the press to quash the impugned order and to approve the appointment, Your Lordship. There's no mention of.
No, he said it's in the pleadings where they've said that the SP school has been instructed to re-advertise the post.
My Lord, Lordship, can you see in my miss case, my Lord?
Okay.
Which case? Which case, Evan? What is the statement that Mr. Yusuf has directed?
Where is that?
My Lord,
Where?
my Lord, I consider, my Lord, I consider there is
Then
no
how
specific.
will we give full protection and stop appeasement? Just take down Mr. H.L. Chari, so then it's in a council with so and so for the petitioner. Issue notice MS that Country G is present on behalf of
1, 2, and 3, Your Lordship.
notice to issue to the respondent number 4 within 3 days. Stop next paragraph. The Leonard Senior Council submits that the writ petitioner who had been duly appointed to the post of you were appointed as assistant teacher.
Assistant teacher.
Assistant teacher in Saint Judah RCLP School, Latyam. Via Sora means. Why is this in school Latyam via Sora?
My Lord, let him Sora. Isn't maybe the name of the place?
No, the name of the village is not Latyam via Sora. You go to Latyam via Sora, of course, but it's not that Latyam. Oh, no? Saint Judah. Yes, is before this court assailing the impugn order dated 20th June 2024, whereby the appointment has not met with approval from the respondent number 3 on the purported ground that the writ petitioner does not possess a 2-year diploma, 2-year DE, D stop EL stop ED diploma. Stop. The Learned Senior Council submits that the finding of the Learned Respondent number 3 is incorrect, inasmuch as the petitioner is in possession of has completed 2 years, completed 2-year diploma course in DLET, and as such, the non-approval and subsequent termination of appointment is arbitrary and illegal. I therefore praise next param MS and Country and praise him allowed to obtain instructions within 2 weeks.
My Lord,
Yes.
my Lord, if Lordship permits, para 9 of my writ petition statement, permanent statement.
Okay,
If Lordship kindly appreciate.
Para 9.
Para 9 in the writ petition.
Yes, sir.
My Lord, surprisingly, the SMC asked the petitioner not to continue to teach in the school by informing that his.
Instruction stop on the prayer of the Learned Senior Council is provided that in the meanwhile the said post shall not be advertised without leave of this court. Yes?
My Lord, SMC may be restrained not to advertise.
Yes, the said post will not be advertised with the leave of this court. Yes, just after 2
I do
years.
appreciate it.
Right, Your Lordship.
Item number 7.
So could you please clarify the situation?
Yes.
All of your own making the situation.
Lordship,
First you said you serve on respondent number 7.
7.
I said 7 doesn't exist.
Yes, because the headmaster of the school received the copies.
Then
Well, at present, no managing committee is
where do you
functioning.
go from here? First you said that 7th important party, they have to appear.
Yes.
So fine, service was, you said I want to take steps. He said 7 management committees been served. Then now you said that they don't exist anymore and you send this poor boy here to make submission that doesn't exist anymore. So at least you apprise the court.
Yes, last time I was here, I apprised the court that managing committee
Then
at
where do
present
you
not
go from
functioning.
here?
It is received by the.
No, where do you go from here then? It doesn't exist, and who received it? on behalf of the managing committee if the managing committee does not exist?
That headmaster received, school.
So why he
Because
receive it then?
He's the all in all in the
You
school now.
compel them to receive it.
No, we just went to sub the copy because
Then
it
what
is
will
a
happen now
dusty.
to your case? You say managing committee is essential.
No, according to me, managing committee is not essential. Basically, here the law point is involved.
Now you say that. Before you said that. Right?
No,
Mr.
my,
Hassan, you
yes,
said
my
that
lord. My lord.
absolute necessity
Last
that they
occasion,
serve.
my learned senior has
Lordship
pointed out
has,
that
opined
because
that,
managing committee is the appointing
Anyway,
authority.
okay, whatever it is, where do you go from here with your case? What do you want?
So my case is that the person who is appointed without any advertisements, without any due process, simply because he gifted the land to the school, he was appointed to the post. Even if he is eligible also, he is eligible to get the post of 4th grade post, not the post of the teacher. That is my grievances. Had the post been advertised, I would have applied. I am also one of the aspirant candidates, want to apply to the post, but I cannot do it because the post is filled
Go
up.
the brief of the state. Yes.
Malad, it is true, Malad. A land was gifted initially in which a school has come into it. And subsequently, one family member was given a job and the person died in harness. So the private respondent...
The person given the job died, he died.
Malad, who was given from the donor's family, Malad,
Yes.
the person was given who is the father of the private respondent. Then, Malad, the SMC, Malad, on their own, Malad, they passed a resolution bringing the son of the deceased as a teacher.
Her son deceased.
Yes, ma'am.
And who does not even have a qualification on a condition that he will get the qualification within 5 years. So there was no approval sought, no information was given with regard to vacancy. So the entire proceeding of appointing him was actually incorrect. That is our stand, madam. And it has been rightfully said also, even if they would have wanted to appoint someone grade 4 because he was not having the qualification. So as of today, he must have, but at the time, madam, when this job was given to him, he does not have the qualification.
Who are you then? What locus do you have to challenge it?
Because I am the one of the petitioners.
No, you're a petitioner. That's why you
I am the petitioner. I wanted to apply the post. Since the post was not advertised, I was deprived of an opportunity to apply the post.
And Mr. Hassan, what's your stand?
My lord, first, my lord, the petitioner has no law. He is age bar, my lord. He is at present he is 38, my lord. And my lord, the appoint.
Correct.
Yes, my lord. Can you see the affidavit there in the affidavit?
Yes. That is different.
Continue.
Yes. Now my father was the headmaster, my lord.
Yes.
After my father was died, my lord, during his service. So to on compassionate and on land donation.
Your father donated the land.
Yes, ma'am. From our
And then
family.
he was from your family donated
My,
the
yes,
land.
my family.
Then your father was appointed as a teacher there.
No, my father was the my lord founder teacher. He established the school along with the present headmaster. So he was the headmaster. So land was donated from my family, my mother's side. Then after death of my father, my family was, my lord, the managing committee on compassionate and on the ground of land donation on two aspects. Looking into these two aspects, the managing committee appointed me, my lord, on certain terms and conditions. And I have given undertaking to the district school education officer, my lord, that within such and such terms I'll complete the eligible criteria, my lord. And with regard to the another aspect, there is 4th grade post, my lord.
Question. Have you attained the qualifications?
Yes, ma'am. Now I have completed my DLED, but unfortunately in the last MTED exam, the first attempt I have disqualified. I have not passed, my lord. So that is the only difficulty I have now, my lord. So
okay, that's not your concern.
My lord. Yes,
who
my
are
lord.
appointed? The thing is that it's for the state authorities to did they submit your appointment for approval for the SDSU?
Yes, my lord. Yes, my lord.
Then that's up to you to find out. Not
Yes,
for
my
Mr. Qureshi.
My limited that I was not given an equal opportunity because if the post is advertised, this is the post.
Now you're already over age.
No, that is his assertion, but which I have not
My
agreed.
lord,
But I have to go. I have to stick to my pleadings only.
Affidavit in writ petition, page 13, my lord.
No, whether
I'm Hashtur Rahman.
37 years.
Yes, 37 years.
That is in 2022.
But that is not the pleading, lordship, here. The pleading is
Doesn't
different.
matter, court can-
Because the court,
from any
that is not the pleading. I mean,
information we can
overage or underage. The pleading is that the post which was to be advertised.
On humanitarian
was not
ground,
advertised.
my resolution was passed, my lord.
The petitioner, by this instant petition, has complained against the alleged illegal appointment of respondent number 7 by the managing committee, respondent number 6 as school teacher. Stop. The ground for challenge is that in the said school, namely Kedargaon or Kendargaon?
Kandargaon, my lord.
Kandargaon.
Kandargaon.
The ground is that in such school, namely Kandargaon SSA LP school, the respondent number 7, who is stated to be from the family of,
yes, my lord,
from the family
land donation,
from the family of the landowner. Take another way around. This is going to be a challenge in the said school. Yes. Landowner, where the school was established, had been appointed even though he did not possess the requisite qualifications, but only with the condition that he attained the same within a period of 5 years. Stop. Next paragraph. Ms. M.F. Qureshi submits that the action of the respondent number 7 is illegal in as much as the notwithstanding the fact that the respondent number 7 may belong to the family of the landowners, he not possessing the required qualifications was not eligible for appointment, and as such the post should have been advertised to allow aspiring candidates like the petitioner to apply. Stop. He further submits that this action of the respondent has deprived, this action of the respondent in matters of public employment has deprived the petitioner of what?
Opportunity to take part in the selection process.
Of a chance to take part in a selection process for which he was sure he would have succeeded. Yes. Next paragraph. MSR Kondi Leonard GA.
Number one, Madam, we have not given any approval to the appointment. And number two, Madam, the land donating, Madam, claim is also being disputed. There's a letter here, Madam.
Okay, we'll record that. MSR Kondi Leonard GA submits that firstly the appointment respondent number 7 has never been approved by the respondent number 3, and that the said action of the respondent number 7 is unilateral. Yes, unilateral. Your affidavit is unilateral. One second. This is affidavit on behalf of the State 7. Yes.
On 8th of August.
Yes, I got it.
2nd of August.
Paragraph.
Madam, you kindly have page numbers 15, Madam.
15. Yes.
So they also, and subsequent documents also will show that we are still yet to give approval.
Unilateral in appointing the in according the said appointment. Stop. Next point you said. What do you have to say?
Regarding the land donation.
Where is that? Annexure 2.
Annexure 3, Madam, annexure 3, that is a letter of the state project director.
Yes.
Madam, first paragraph and third line also, Madam, it says there is no legal document to substantiate that a lot of land was donated by late Hafizur. So it's a disputed question, Madam.
Yes. It is further submitted by the GA that even the factum of donation of land by one late bracket Hafizur Rahman for the purpose of construction of Kedargaon SSLP school is also doubted. Stop. He therefore submits the entire matter of donation of land and appointment not being with the full knowledge of the state respondents. You don't have any other submissions to make.
His appointment is actually incorrect.
To do it, the appointment granted to the respondent number 7 is without. Yes, but it's granted to the respondent 7 by the respondent number 6 school management committee is totally unauthorized and not has not been is unauthorized and without approval of the state respondents. Stop, Mr. S.K. Hassan.
Yes, my lord. My lord.
Mr. S. Hassan, next paragraph appearing on behalf of
for respondent number 7, my lord. My lord, land was donated, my lord, at annexure. I have filed my affidavit, my lord, at page 7. The district mission coordinator SSA West Garo Hills Sura is the party, my lord. Page 7, my lord.
Yes.
Page 7.
In reply to the submissions, has taken the court
yes, my lord.
to a deed of gift. Deed of gift?
Yes, my lord.
Annexed to the affidavit.
Annexure 1, my
Annexure
lord.
1.
Yes, my lord.
To substantiate
and with regard to
contention that the deed of gift dated
yes, my
25 to
February 2021, my lord.
Yes, to substantiate his contention that a donation is not registered.
But my lord, yes, my lord, it's not registered, my lord.
A deed of gift,
it's notarized, my lord. At Tura, my lord.
How many? Mr. Hassan also reply has. At annexure 1 to the affidavit, his contention that a valid donation had been made
yes,
by where's the signatory here?
Yes, my lord. At my lord, page 10, my lord.
By one.
The Nurima Kazi.
Srimati
Nurima Kazi.
Kazi BB.
BB, yes, my lord. The mother of the respondent number 7.
Gift, though not registered, has been accepted by the district mission coordinator.
Yes, my lord.
SSA Garo Hills, and has been duly notarized.
Yes,
he further submits that. What?
Yes, my lord. At annexure 11, my lord, the director of school, my lord, state project SIMAM, my lord, SSA, has white letter dated 5th March 2021, my lord, directed to the district mission coordinator to approve, my lord, to issue necessary order, my lord.
Yes.
Thereafter, my lord,
that,
annexure 10.
On 5/3/2021, the state project director,
yes, my lord,
State Education Mission Authority of Meghalaya, had also directed the district mission coordinator,
yes, my lord,
West Garo Hills, to examine the proposal,
yes, my lord,
in line with government orders.
Yes, my lord.
Yes.
Thereafter, my lord, annexure 10, the district mission coordinator issue order, my lord.
Which
14/12/2020, my lord. This one? Letter number 96 last.
Yes. And that on 14th.
Yes, my lord.
And that?
My lord, thereafter, my lord, district mission coordinator also approved, my lord.
When is this?
My lord, on 2020, my lord.
Now, when they examine the proposal 21,
my lord,
that
before,
means you pre-approved it.
My lord, it's again, because, my lord, because of the complaint, it again goes to the director, my lord.
Anyway, though he submits the approval had already been obtained, or though the proposal had already been sent,
yes, my lord,
as far back as on 14/12/2020. Stop. He therefore contends that there is no illegality in the appointment of respondent number 7, except that he was to qualify himself,
my lord, yes,
accordingly to enable him to retain the post. Stop. Next paragraph. I've heard the counsel for the parties. Firstly, it appears that the writ petitioner has not clearly established his locus as to his interest in the entire.
No, sir, I have already stated.
Entire.
I have already stated that had the post been advertised,
Yes,
I would have applied.
Yeah, this locus in the entire. Had the locus, and that there is no gainsaying that if the same had been advertised, he would have qualified.
I would have applied for the right. It's a public employment.
Notwithstanding this fact, this court on examination of the materials on record and on submission of the parties, deems it fit at this stage to. What do you want to do?
My lord, on humanitarian ground, my lord, my family has donated the land, and I have no other source of income. My lord. I have two sisters.
There's a conflict. There's a conflict because first he said that it was donated by the late Hasibur Rahman.
No, my lord.
Hasibur Rahman, and then now your deed of gift is of 2021.
Yes, my lord.
2021.
My lord, may I please?
2021. Also, deed of agreement. Sorry.
Deed of agreement.
Deed of agreement 2021.
Yes, my lord.
Which is by another person, but then your other annexures refer to 2020 when the appointment of the earlier person be sent for.
My lord, on 2020, my appointment was approved.
Notwithstanding this, notwithstanding the circumstances and the facts, it appears from the. Notwithstanding it appears that the matter needs further examination by the authorities concerned, and as the writ petitioner is since overaged. No relief can be forthcoming.
There is not the pleading of either parties.
Authorities to take appropriate action in the matter. Yes.
Hello.
The matter stands disposed of. No point keeping it. What's the point?
Hello.
No one's a complaint. Only you have complained. You're overaged. By affidavit, we're not going by submissions. By affidavit on record in 2022, you were 37 years old. Now you're 39.
Yes, but that is not the pleading, though. Not the
no need for pleadings, an affidavit.
But maybe he's already studying somewhere. Departmental candidates, he may get some relaxations. There may be some possibility.
You get a new birth certificate then, like they do. Yes.
May I please, Your Lordship? Your Lordship, I humbly let this matter be taken up and of the board, Your Lordship. Because Mr. S. Deb is next to courtroom 3, Your Lordship.
Out sometime?
Please, Your Lordship.
You're not leaving Delhi right away?
No, Your Lordship. 12 o'clock, the division bench will be sitting at 12 o'clock. So,
yes, what do you have to say? Where's Mr. Day?
He's next to courtroom 3, Your Lordship.
Where's Mr. Deb?
Deb is next to courtroom 3, Your Lordship. Mr.
Next
Day,
to courtroom 3?
Yes.
Where's Mr. Day?
Mr. D is on sanction leave, Your Lordship.
Then we'll take it when?
Your Lordship, because there is nothing in this matter, because I have seen.
You got instructions?
No, I don't have instruction, Mr.
Yes,
Esther.
as Mr. S. Dev is not present, this is a matter after 1 week.
Yes, madam.
Yes.
Grateful.
Daily list item number 1.
Please, Lordship. As per the last order, I am supposed to get instruction. The Lordship, I have received this document only by yesterday. I have tried to communicate to the petitioner, but the petitioner unfortunately is in the.
What document got yesterday?
They have given this document that say that some amount has been paid.
When was that amount paid? They given last date.
Yes. Correct? No, but they have given yesterday only. But it is reflected in the order, but they have not given to me. Yesterday only they brought in.
This is given to you on 19/6.
No, it is reflected, but they have not, basically they have not given. She has supplied this copy yesterday.
Correct.
Yes, Your Lordship.
Why?
Your Lordship, because due to some oversight, Your Lordship.
Due to some?
Some oversight, Your Lordship.
On that day itself, Mr. Day had shown to the court on 19 that this amount paid to him, and court passed order hand over copy to him.
Yes,
no, on that day they don't give, just give it to the court. Yesterday only
Next
they
time
have.
What you do is that when you see like that, then you take out your phone and take a photograph. Take a picture of it. Rather than wait to be served physically.
Yes.
Mr. P. Sama submits that though this court had ordered that a copy of the document be a copy to be given. The same must have been handed over yesterday itself. As such, the police are allowed to 1 week further time for instructions.
Lordship.
How much money you've got totally?
They have 5 lakh.
Then, very handsome amount you got.
Yes, but still you want to get a clear instruction because this petitioner is sick now. I could not communicate him. Let him
You
go
want
to
material instructions.
Let him go to the document. Maybe.
Item number 2.
Yes.
Much obliged, Lordship.
Yes, if
Here in this case, the new
file
newly
affidavit, we
implemented.
have for number 5? No.
Your Lordship, the affidavit that was filed was on behalf of the personal department itself, Your Lordship.
Shall suffice.
So we'll rely on that.
Let the matter go for hearing.
Then yes, MSZ in Nonkani Landed GA submits that the affidavit filed earlier on behalf of respondents number 1, 2, 3 shall also suffice for respondent number 5. Often this matter for hearing after 2 weeks, yes.
Obliged, Your Lordship.
Item number 3.
Be pleased, my lord.
Rejoinder file.
My lord, the matter may be posted for hearing. My lord. I only filing any rejoinder.
Then don't take time.
My
Why
lord,
keep
my
taking the rejoinder and then you don't file rejoinder?
Well, in the meantime, my lord, the records may be kindly called for the concerned department.
Why?
The
What
lordships have gone through the affidavit filed by the private respondent. Your
Who's
lordships-
not respondent?
Respondent number 5, my lord.
Why? What does it say?
Your lordship kindly have the last page, page 33.
That is by
Respondent number 5.
no 5. Last page 33.
My lord.
Yes.
My lord, your lordship, see, this is the form 17, in terms of Rule 52 of the Meghalaya Civil Service Pension Rules. Here, my lord, the signatory
Tunika
is the-
Das.
my lord. In fact, this form is supposed to be filled up by the government servant during his lifetime.
Now who's now?
Yeah, my lord, I'm aggrieved against the release of the pensionary
Now
benefits.
you are there. Your name is there also, Brigita Mara, daughter.
My lord, your lordship,
Then
have
is
my...
Tunika Das' wife still alive?
Yes.
Then
My
she'll
lord,
have
she
first
is
claim
the
on-
second wife of the deceased employee, my lord. My late
was
father.
he divorced from your mother?
Not divorce actually, my lord. She passed away.
Okay.
Your lordship, another aspect, my lord, here, even with regards to the gratuity, whether any nomination was been made by the deceased employer during his lifetime, even that thing also has to be taken into consideration, my lord. If your lordships have the provisions, my lord.
See this affidavit. They got a marriage certificate also.
My lord. Well, I'm not claiming for the family pension. I'm only with regards to the pensionary benefits, the LEB as well as the gratuity.
What's your age now?
I'm 26, my lord.
First claim will be the yes you. Yes.
Meghalaya Civil Service Pension Rules.
But you're already receiving the Mr. Kharsoom. You're already receiving the pension now. You're receiving monthly. Is that correct? Then she's a legally married wife. If the
She's
person
legally
is-
very right. My lord, here, I have placed an objection before the concerned department. Now, after 2 days of my objection, my lord, the pensionary benefits were released to the private respondent.
Because in the service book, she's a nominated person.
If your lordships have my
Naturally, you go by
writ petition,
records.
my lord, if your lordships have my writ petition, Annexure 7, page 22.
Next 7 page.
22. These are the list of the nominees, my lord, as per the actual service sheet. Altogether, my lord, there are 6 nominees. First one, my lord, is the wife of the deceased. Second is the father of the deceased. Third is the mother of the deceased. And fourth, my lord, the daughter, who is the petitioner.
Now, who's this number 2? Sri Shashiram Das.
He is the father of the deceased, my lord. Deceased employee.
Oh, Bhim Kumar Das' name?
My lord.
Okay.
In no way, my lord, the name of Tunika was reflected, but as per Form 17 annexed by the respondent number 5, subsequently, my lord, it was entered.
Form?
Form 17, my lord, which I have taken your lordship to the affidavit filed by the respondent number 5.
Now you will hear it then. How do you record the list right now? Yes, Mr. H.C.T. Sambit that the no rejoinder be filed. Only is a matter for hearing on so and so.
Item number 4.
May I please, Your Lordship? I humbly pray 2 weeks' time, Your Lordship, to file the affidavit, Your Lordship. I humbly pray 2 weeks' time, Your Lordship, to file the affidavit.
How many times have you taken? A lot of times. What's the matter about?
This is a non-payment of the gratuity and other service benefit. This is the third time of litigation.
2 weeks further time as granted to so and so for respondents to file affidavit.
Item number 5.
Lordship, in this case, I am appearing for 1 to 4. I have already filed my affidavit.
Yes.
Lordship, so far as respondent 5 is concerned, we are relying on the affidavit filed by the Nehu.
Lordship, respondent 6 and 3.
6 is whom?
The selected candidate. Lordship, he had gone to his hometown for some urgency claim for something.
UGC?
I'm appearing for UGC, my lord. We have already.
Yes, Mr. Imran Upir, counsel for respondent number 5 submits that the reliance on behalf of this respondent, reliance will be placed on the affidavit filed by the respondents 1 to 4. Stop. MSP Kharwanlang for respondent number 6 prays for further 2 weeks time to file affidavits. Prayers allowed. When do you file affidavit?
Manoj.
When was
But
it
it has
filed?
been long time.
Okay, then that's been recorded earlier. Yes.
8 May, Your Lordship.
Yes?
8 May.
And the list after 2 weeks is.
Item number 6.
My lord.
My lord, state has not filed affidavit here, my lord. On the last occasion, the senior has filed affidavit in which lordship has stated, was of the view that state should also file affidavit because the claim is for the damage to the agricultural land.
You ask for inspection to be done by the state
I
and
have
to
verify
assess.
because, my lord, here we have the PWD and the Deputy Commissioner's Office. So far as the instruction from this one department, they don't seem to be aware of that. So I'm
See,
looking
the
for
thing is that
instruction
if
from
they
the
are
other side.
cultivators being
My lord, I'm
deprived
aware-
of cultivation,
I'm
it
aware of
is
that. However,
the
my
duty
lord-
of the state to secure the livelihood also.
My lord, what we have through the petitions, what we can say, we have been corresponded with the letters. So what they have done with the letters, my lord, what action was taken, I'm yet to receive instruction on that.
Otherwise, we'll call who's the deputy commissioner and the chief engineer PWD.
My
If
lord-
you're not receiving instructions, you inform
My
the
lord,
court.
we are yet to have
We are not so. We don't want to call, although we will call them because if the cultivator is not deprived, and if they made repeated representations, they're not getting water, soil has been dumped, how will he survive?
It's the second time I'm asking for instruction, madam. Can you give me some more time, madam? I'll possibly try to file the affidavit within the next day, madam.
When the price of development for people to drive their cars
I don't-
on the
I
highway
don't-
doesn't mean that those people living the sides,
Madam, I
will
believe
be.
there is no nothing been done wrong by the state respondents, my lord. So it's just that
At least state respondents are the people on the ground who can assess, because see the other cases where the states have been asked to assess and they have done assessment and NHIDCL have paid. You see, that's what's happened. If you owe, not saying your damage, if we can talk about absolute liability or
My lord, that we are yet to get instruction that, because my lord, we are just getting in touch. Perhaps my lord, there was a certain action was taken by the office of DC, my lord. But we are just waiting in formal writing, my lord, and those reports, my lord, if at all inspection was conducted.
MS Arkolni, on behalf of respondents 3 to 11, submits that no instructions have been forthcoming from the state respondents in spite of instructions being sought. The matter concerns the destruction of cultivable land of the petitioners. It's the duty of the state to guarantee the livelihood of such people, of such citizens. So expected that on the next date appropriate instructions shall be on board, failing which further orders will follow. Further orders means we'll call them. We'll ask them to go. If I call them today, I'll ask them to go in the morning, to go to that place. I'll make the chief minister stay overnight also. We've seen that as happening everywhere. People have been, they're building roads, they're dumping soil, dumping to the water, dumping into people's lands. There are many areas where I've got personal complaints, whereby, the water sources are just have finished because they dumped and the water that goes to paddy fields is over. They're not getting a salary like those engineers and all, where they don't have to worry about where next meal comes from. You read the preamble, social justice means what?
We'll make sure that on the next the proper instruction will be forthcoming.
Objections been filed?
Yes, Your Lordship.
You file objection?
Yes.
What's your objection? What's the matter about?
This is the matter where to dispose of the
Yes.
representation, Your Lordship. To dispose of the representation where
This matter has already been disposed of.
Where's the order? Or disposal or representation? Where's the order of disposal representation?
Well, initially a case was pending. When the recruitment process was going on, a
Yes.
case was pending against the petitioner, and this is not in dispute. So what happened subsequently was the matter was before the Honorable Court, and the Honorable Court asked us to consider their representation. We considered.
Where's that
since
representation?
there is a pending.
Here,
Where
the
is it?
order is in the last.
Madam, it was already disposed of. After we considered, it was disposed of. They again filed a review. Even the review was disposed of.
Then?
They
What
said
do you
in
mean?
the review petition that
Yes, Mr. Deb. Why are you acting as if you like an onlooker instead of yes?
Your Lordship, what had happened is petitioner was appointed.
No, we don't. We know what happened. Now you have prayer for a disposed representation submitted by state council. That's already
Because
been
it's on new circumstances.
disposed
Now
of
I have
twice
been,
over.
No, now I have been discharged from all liabilities of the criminal case. The earlier round of writ petition and review.
Fine. Now, what do you want now?
I want them to consider my representation, Lordship.
even this representation has been considered
So it's been considered.
and
It's been
disposed
considered.
of.
You produce the order the next date. Yes,
It's in,
MSS
Annexure 1.
so and so for the Learned GA submits that the complaint or the allegation of the petitioner that a petition has not been disposed of is incorrect, as the same has been disposed of. She directed to produce a copy of the
Page 16. It's at
order
page
disposing
16
of
of your
petition
Annexure 2, page 16
of the affidavit.
of the affidavit.
Madam.
Oh, say that then.
16.
Okay, annexure 2. Final, yes. Finished.
I may be allowed to take instruction, Lordship.
You didn't see this affidavit?
As per the order, it was yet to be filed, so they had given us last time. We're not sure whether they'll file the same one or not.
Yes, hold on, MSSI Learned GA has submits that this representation of the writ petitioner dated 5th July 2023 has since been disposed of, and the orders annexure 2 to the affidavit file. Stop. Next one, Mr. S. Deb, please allow to appear instructions. Just up to 2 weeks. Yes.
Item number 8.
This is pension.
Yes, Lordship, because there is a memorandum, Your Lordship, passed by the JHDC. They have approved. To that effect, their order also has been passed by.
What?
They have approved that the formula for calculation of gratuity.
So what do you want here?
Yeah, for payment of gratuity and other service.
As per the formula?
Yes, yes, as per the formula.
I am paid 2 weeks' time, Your Lordship.
Two weeks time as paid, allowed. You can't never file his JGC affidavit, it appears.
Item number 9.
Much obliged.
Much obliged, Lordship.
Lordship, fetch the
You obtained correct address?
Yes, Lordship, but according to the website, yes, Your Lordship, but according to the website, there has been no positive outcome so far.
There has been no
positive outcome so far. So, Your Lordship, I pray that I may be allowed to take additional steps to.
No. Last time you said that you wanted 2 weeks time to obtain the correct address
Yes,
of
Lordship.
678 to take fresh steps.
Yes, Lordship.
You've not obtained it.
I've obtained it and I've already taken steps, Your Lordship.
Okay, then.
There's been no positive outcome as per the website, Your Lordship.
Outcome meaning that they have not been served.
No, Your Lordship. Your Lordship, I pray that I may be permitted to take additional steps by way of Dusty.
You can serve a Dusty if you don't know the address.
Yes, Your Lordship. Yes, Lordship.
Who's 6, 7, and 8?
6 and 7 are the schools, Your Lordship.
Christian.
And 8 is the private respondent.
6 is headmaster.
Yes, Lordship. 6 is where I was first appointed to, Your Lordship.
2 headmasters, my lord, 6 and 7.
6 is headmaster, 2 headmasters are there?
Yes,
2
Lordship.
headmasters, my lord, 2 different schools.
Okay, Mr. Lasangoya, another council petitioner says that submits that on obtaining the correct address, fresh steps had been taken on respondents 6, 7, and 8, but the same, but he could not obtain the status as to whether they have been served or not. Stop. He therefore prays that he be allowed to effect service or effect notice by personal service.
Yes, Lordship.
So the prayer is allowed. The prayer is allowed just after
3 weeks.
3 weeks, yes.
Right, Your Lordship.
Item number 10.
Lordship, I'm praying for further 2 weeks' time to file affidavit in this matter, Lordship.
Where's the petitioner? 2 or 3 weeks?
3 weeks, Lordship.
11.
None appears for the petitioner.
I have a similar
Pray
prayer.
for the 2 weeks time, 2 or 3 weeks time granted to the respondent.
My lord, I am for the petitioner in item number 11, my lord.
Yes.
Lordship, I
Warrant
have
Officer Samuel Kutti.
Yes, my lord.
Yes.
Affidavit in opposition is still awaited, my lord.
I have a similar prayer, Lordship, for this matter.
This was filed when. Okay, 2 weeks, yes.
Highly obliged, Lordship.
Item number 12.
In item number
Connected.
12, my lord, we are also waiting for the
Connected
affidavit,
matter,
my
Lordship.
It's connected to the other one?
Yes, Lordship.
No,
with
no,
with
no,
item
my lord, it's a
11.
different matter.
With item
2
11.
weeks, yes.
Highly obliged.
My lord, deep your lordship.
Hearing. Supplementary list. Item number 9.
Hearing here. Itu ada fotokopi buku. Nampak tu kan? Compilation. compilation jonga. Act 94 Act. Yes.
Please, Your Lordship.
Now you finish those points.
Lordship.
Now you
I'll
go
just
on to-
confine myself to the cross objections.
Okay.
So
Today's
there were broadly about 4 points that were raised, my Lord. One that
Yes.
the first was that the burden of proving the market rate
Yes.
was on the collector, and the collector was duty bound to adduce evidence. In support of this, my Lord, my learned senior has referred to the case of Periyar Perakumi. This is in page 30 of their compilation.
Compilation or
The judgments placed by the respondents.
yes, page 30.
The relevant page is at page 39.
Page 39.
Para 15. Lord. This is what my learned senior has referred to.
Mr. Jindal, retired in para 15, 16.
Yes, my Lord.
Yes.
15 and 16 I read.
Yes, 15, 16, yes.
So far that point is concerned.
Yes.
So the point being canvassed was that it is the duty of the collector
Yes.
to lead evidence to establish the market rate. So may I read, my Lords?
Yes.
In the light of these principles, the further contention that having rejected the documents produced by the state, the High Court ought to have relied upon the documents produced by the appellant as comparable sale and would have confirmed the compensation awarded by the civil court does not impress us as well founded. It is well settled, or that the amount awarded by the land acquisition collector forms an offer, and that it is for the claimants to adduce relevant and material evidence to establish that the acquired lands are capable of fetching higher market value, and the amount offered by the land acquisition collector was inadequate, and he proceeded on a wrong premise or principle. In Ezra versus so-and-so, it was held that the amount awarded by the collector forms an offer. It was reiterated by this court in so-and-so. Can you see the next paragraph? In a reference under section 18 of the Act, the burden of proving that the amount of compensation awarded by the collector is inadequate lies upon the claimant, and he must show affirmatively that the collector has proceeded upon a wrong basis. The nature and burden of establishing that he was wrong depends on the nature of the inquiry held by him. It is equally well settled that whether claimant leads no evidence to show that the conclusions reached in the award were inadequate or that it was offered unsatisfactory compensation, the award has to be confirmed. So this does not help the proposition of the claimants. This clearly lays down that the award made by the collector is merely an offer. And when a section 18 proceeding is launched, it's launched on the premise that the award or the market value offered by the collector is inadequate. So therefore the initial burden to prove that this amount is inadequate squarely lies upon the claimants. Okay. Kindly also see Placitum D at page 40. In that case, it was held that the evidence produced was untrustworthy. Same is the view of the Bombay High Court and so. Can you see the last line, my lord? It is also the duty of the court to adduce evidence and what it qualifies with in rebuttal. So therefore, if some evidence is brought on record by the claimants and it is felt by the collector that those rates are not a correct representation of the fair market value or it is inflated, that is when the collector will come in and adduce evidence in rebuttal, not otherwise.
No, but Mr. Jindal has said that it was never done. The collector never adduced the evidence.
No, I'll show from the records, my lord, that there's no satisfactory evidence in the first place. So there was no need for the collector to step in. This would come in, rebuttal would come in when there is some reliable evidence which has been brought in. And the case of the claimants is that reliable evidence is those 3 sale deeds, the unregistered sale deeds, Exhibit 3, 4 and 5. That itself has been rejected and discarded by the court. So there was no need for the collector to step in because the collector did not feel that they had brought in inflated prices. I'm sure in this case what had happened, it was a case where there was a default on the part of the state, on part of the collector. They did not participate in this case properly. But then that does not really mean that the rates which have been brought in by the claimants have to be accepted as the gospel truth, my lord. Okay. So this judgment has to be distinguished.
Okay, just 1 second, let me do it. This is Periyar.
The other judgment that was referred to.
1 second, 1 second.
My lord.
Yes.
The second judgment is at page 50 of their compilation. Land Acquisition Officer versus V. Narasai.
So using their judgments only?
No, I'm going to use mine as well, but I'm just distinguishing these judgments on it.
Yes.
At para 50 minutes, the relevant page is 55.
Para 55.
Para 55, page, sorry, I apologize, page 55, para 13 and 14. My learned senior had referred to para 13.
13, yes.
So I'll read para 13 and 14 both. If your lordships have it.
Yes.
If the position regarding admissibility of the contents of a document which is certified copy falling within the purview of section 57(5) of the Registration Act was as adumbrated above, even before the introduction of section 51A in the LA Act, would there be any legislative object in incorporating the said new provisions through Act 68 of 1984? It must be remembered that the state has the burden to prove the market value of the lands acquired by it, for which the state may have to depend upon the prices of lands similarly situated which were transacted or sold in the recent past, particularly those lands situated in the neighboring areas. The practice had shown that the state officials, it was a burden to trace out the persons connected to the said transactions mentioned in the sale deeds and then to examine them in the court for the purpose of proving such transactions. It was in the wake of the aforesaid practical difficulties that the new section 51A was introduced in the LA Act. When the section says that certified copy of a registered document may be accepted as evidence of the transaction recorded in such document, it enables the court to treat what is recorded in the document in respect of the transactions referred to therein as evidence. The words may be accepted as evidence in the section indicate that there is no compulsion on the court to accept such transaction as evidence, but it is open to the court to treat them as evidence. Merely accepting them as evidence does not mean that the court is bound to treat them as reliable evidence. What is sought to be achieved is that the transactions recorded in the document must be treated as evidence, just like any other evidence, and it is for the court to weigh all pros and cons to decide whether such transaction can be relied on for understanding the real price of the land concerned. Now, my learned senior had referred to para 13. Now, this was, and there is an observation made here that it is the duty of the court to prove the market value. But this was in light of section 51A, and what was the practice followed before 51A? Kindly have section 51A, my lord. So 51A was introduced after the amendment. Prior to the amendment, my lord, what was mandated under the Act was that the parties would have to bring on record the original sale deed. And they would have to prove that document.
If just bring certified copies,
yes,
good enough.
So it dispenses with the requirement of bringing the original documents and examining the vendor and the vendee. So in light of that, in that context, this observation has been made in para 13. So it does not say that the burden of proving the market rate is on the state. It is only in the context of 51A. And what was the practice before 51A? That's all. So on the issue of the burden, my lord, and who the burden lies on, I'll refer to a judgment 2004, 10 SEC 745.
On burden.
Lordship.
Aye. 2000?
2004, 10 SEC 745.
745. Paras?
Relevant para is para 10 onwards, my lord.
Yes.
Which is at page 754.
Yes.
My lord. This reads, before examining the merits of the contentions raised, it will be useful to bear in mind the legal principle in the matter of determination of compensation. The collector's award under Section 11 is nothing more than an offer of compensation made by the government to the claimants whose property is acquired. The burden of proving that the amount of compensation awarded by the collector is inadequate lies upon the claimant, and he is in a position of a plaintiff. The court has to treat the reference as an original proceeding before it and determine the market value afresh on the basis of the material produced before it. The claimant is in the position of a plaintiff who has to show that the price offered for his land in the award is inadequate on the basis of the materials produced in the court. The material produced and proved by the other side will also be taken into account for this purpose. So this again lays down that the initial burden of proving that the rates offered by the collector are inadequate entirely lies on the claimant.
Yes. Yes.
The next issue, which was argued
Only
before the
para
court,
10.
only para 10 minutes. The next issue that was argued was that once an unregistered sale deed, which suffers for want of registration or unstamping, is admitted in evidence and is marked as an exhibit,
Yes.
the same has to be treated as binding on the court, and the contents have to be treated as the gospel truth. So, in support of this proposition, my learned senior had referred to the judgment of Javed Chand and Pukhraj, that is at
75.
page 75, my lord.
(1962) judgment.
Lordship.
1962. Yes.
What was read out is at page 76 towards the bottom end.
When instrument.
Lordship, in our opinion, the second last line
Yes,
in that
like the
paragraph.
misdirected belief.
In our opinion, the High Court misdirected itself in its view of the provisions of Section 36 of the Stamp Act. Section 36 is in these terms. I'll just skip that and come to the next paragraph. That section is categorical in its terms that when a document has once been admitted in evidence, such admission cannot be called in question at any stage of the suit or the proceeding on the ground that the instrument has not been duly stamped. The only exception recognized by the section is the class of cases contemplated by Section 61. Now, I've read the entire judgment. All it holds is that during the process of exhibiting a document, if an unregistered and unstamped or insufficiently stamped document is marked as an evidence and no objection is raised by the other party, that order cannot be recalled. That exercise cannot be reviewed, cannot be recalled. That document will remain. Now, that is the only thing that is laid down by this judgment. It does not go any further to lay down that the contents of the document will be binding upon the court. So that is the limited purpose
It's
of this
only
particular
to
judgment.
acceptance only.
Only with regard to the exercise of acceptance, my lord. Only on the question of admissibility.
Yes, only.
At that stage. Nothing further. Because there are two components now. One, that it has been marked as an evidence.
Would it naturally mean that what the recitals of that
No,
whatever?
that's where I'm just drawing a distinction. That there are different components to this. At the stage of
But
evidence,
if you take a document to be fine, admissible in evidence. Now, it doesn't mean the paper is admissible.
Exactly.
What about
whether
the
it's
recitals?
reliable or not, that will be for the court to decide, my lord. Whether that document is genuine, whether that document is a reliable document, whether the contents are genuine, will be for the court to decide. So,
Not on question acceptance of content.
this is only on the issue of acceptance. That it has been marked cannot be reviewed. It could have been a mistake on the part of the court, mistake on the part of the counsel for the opposite side, that this issue was not raised. And therefore, it is marked as an exhibit.
Interesting point, Mr. Jindal, you note that whether once a document is admitted, whether admission will pertain only to the admissibility of document without and the courts
It looks
has
illogical.
discretion.
It looks illogical.
No, I'll come to
court
that.
has discretion not to accept the contents.
Yes, ma'am. Kindly consider this. I make an agreement saying I have sold the Taj Mahal to somebody.
It will depend.
I'm just talking about whether it's logical or not. Now, would it be on the court to say that this is binding on me simply because it has entered into evidence and it has been marked as an evidence? Simply because it is marked as an exhibit, would it mean that the recitals in that sale deed are true? Because I say that I have a deed of declaration in my favor, or I have purchased the Taj Mahal, or whatever the case may be. That can't be. It is for the court to examine it.
Okay.
So I'll just come to that judgment, my lord. The next one, this is an unreported judgment of the Honorable Supreme Court. Sirikonda Madhava Rao versus N. Hemalata. This is decided on 14th November 22.
On
14th, you will find that on the next page, 14th November 22.
one second. Yes.
Lordship. It's a short judgment, Lord. I'll read the entire thing. Leave granted. It is accepted that the document dated 14/3/93, purporting to be an unregistered sale deed, was marked as exhibit number A1 on 27/11/2006. In view of the aforesaid position, we do not think that the impugned judgment passed by the High Court directing that the aforesaid document should be demarked and not be treated as an exhibit is incorrect and in accordance with law. Once a document has been admitted in evidence, such admission cannot be called in question at any stage of the suit or proceedings on the ground that the instrument has not been duly stamped. Objection as to admissibility of a document on the ground of sufficiency of stamp has to be raised when the document is tendered in evidence. Thereafter, it is not open to the parties or even the court to re-examine the issue, the order or issue. To this extent, the impugned judgment is set aside and the appeal is allowed. We clarify that we have not commented or examined question of effect of purported non-registration of the sale deed in terms of the TP Act and the Registration Act. These questions and issues are left open to be decided by the trial court. All pleas and contentions raised by the parties in this regard can be raised before the trial court, which will examine the said aspect and other issues without being influenced by the present order and impugned judgment. So this issue is left aside because what the court will have to decide is whether that unregistered sale deed actually has any effect on the property.
Okay. This is once a document has been accepted.
Lordship.
Yes. Has been admitted, you can say. Once it has been admitted, it cannot be recalled.
That's only what it decides. Whether that document should, whether the court should attach any importance to that document and whether that document will be binding on the court, that is left open to the court.
Okay.
Because what we are dealing here, my lords, is with the issue of the market value. Now, I have referred to other judgments where courts have held that it is for the court to examine whether the market value appearing in those sale instances are genuine and fair. If it appears to the court from its own experience that those prices appear to be inflated, the court may discard that. And your lordships would have noticed from the reading of section 51A, it does not talk about unregistered sale deeds. It only speaks of certified
copies.
So prior to 51A, what was required was the original sale deed. After 51A, they've dispensed with that requirement and they've said you don't need to bring in the vendor and vendee. All is sufficient is to bring the certified copy. That's all. So they've lessened the burden on the parties. The next judgment, my lords, is one also which my learned seniors relied upon. V. Narasaya. I was just referring to it earlier. That is at page in your compilation. This may be at page 50 of the compilation. Para 14. I just read out para 14, but in this context, I'll read it again. At page 55.
2001.
Yes, sir. 2001, 3 SEC, 530.
Mr. General relied on para 13.
Yes. So I've distinguished para 13 on the other issue, but insofar as the question of acceptance of the document in evidence, I'm referring to para 14.
Yes.
Lordships have it?
Yes, yes.
So Lordships will find in section 51, the expression used is the document, the certified copy of the
why
document.
Why you go to judgment? What purpose? Why are you coming back to it?
My lord, because if your Lordships kindly have section 51 again, I'll just take your Lordships through it.
Yes. Acceptance of certain copies evidence.
Lordship.
Yes.
So if your Lordship see 51A, it reads, in any proceeding under this act, a certified copy of the document registered under the Registration Act, including a copy given under 57 of that act, may be accepted as evidence of the transaction recorded in such document. It does not say shall be accepted. So what is the meaning of this? That has been discussed in para 14 of Narasaya's judgment.
The words may be accepted.
Yes, my lord. May be accepted as evidence.
Yes.
The words may be accepted as evidence in the section indicate that there is no compulsion on the court to treat such transaction as evidence, but it is open to the court to treat them as evidence. Merely accepting them as evidence does not mean that the court is bound to treat them as reliable evidence. What is sought to be achieved is that the transaction recorded in the document may be treated as evidence, just like any other evidence, and it is for the court to weigh all the pros and cons to decide whether such transaction can be relied upon for understanding the real price of the land concerned. So in this case, in light of section 51, a certified copy is brought on record. Even then the court holds that by dint of the language of section 51A...
The new act, do we have any provision like 51A?
Perhaps I'll have to examine. I'm not really... I'll have to examine that.
Yes.
So what section 14 lays down, that the expression may be accepted in evidence actually means that it may be marked as an evidence. Parties may be permitted to rely on it.
But it has to be
But it will
tested.
depend on the court whether to accept it as genuine or not.
It has to be tested, you mean?
Lordship. So again, it says that it does not mean that it is binding on the court. Simply because it is certified or simply because it has been accepted and marked as evidence or as an exhibit does not mean it would be binding. It would be open to the court to examine whether the contents of that document are reliable enough. That's the third judgment is one again that is from their compilation. At page 107, Cement Corporation of India. This is a judgment of the Constitution Bench where a question was referred to the Constitution Bench. What had happened was, my lord, that there was a question raised on the scope of section 51A, whether vendor and vendee should still have to be examined, despite the fact that there was a dispensation with the requirement to bring in a original sale deed. Now, this appeared to have been passed, Narasaya's judgment, which I just read out, appeared to have been passed without taking into consideration another former judgment of the Honorable Supreme Court, which again my learned senior is referring to at page 171 of his compilation, which is a judgment of Special Duty Collector versus Kurra Sambasivar Rao. So, this was placed before, noticing that there was some sort of a conflict, this was referred to the Constitution Bench. And what the court has held, kindly have page 20 minutes, page 116, para 20. So first I'll just point out that they're also relying on this judgment of Kura Sambasiva Rao that has been overruled by this particular judgment of the Constitution Bench. That is recorded in para 20. The above view of the court in Kura Sambasiva Rao case, in our opinion, is not the correct position of law. Here it had been held that despite the fact that under 51A the parties are permitted to bring in a certified copy, yet it is necessary that in accordance with the Evidence Act, both the vendor and vendee have to be examined in court so that the document can be proved. However, in Narasiya, the court held that this is also not required. Only the bringing the certified document on record is more than enough. Now, as far as the other question is concerned, my lord, I am referring to para 28 onwards at page 117.
Yes.
As this reads, Section 51A of the LA Act may be read literally and having regard to the ordinary meaning which can be attributed to the term acceptance of evidence relating to transaction evidence by a sale deed. Its admissibility in evidence would be beyond any question. We are not oblivious of the fact that only by bringing a documentary evidence in record, it is not automatically brought on record. For bringing a documentary evidence on the record, the same must not only be admissible, but the contents thereof must be proved in accordance with law. But when the statute enables a court to accept a sale deed on the record evidencing a transaction, nothing further is required to be done. The admissibility of a certified copy of the sale deed by itself could not be held to be inadmissible, as thereby a secondary evidence has been brought on record without proving the absence of primary evidence. Even the vendor or vendee thereof is not required to be examined themselves for proving the contents thereof. This, however, would not mean that the contents of the transaction as evidenced by the registered sale would automatically be accepted.
Yes.
Then I'll refer to the next page, page 119, para 33. 119.
Submission.
My lord, the submission of Mr. G. Chandrasekhar to the effect that the contents of a sale deed should be a conclusive proof as regards the transaction contained therein, or the court must raise a mandatory presumption in relation thereto in terms of 51A of the Act, cannot be accepted, as the court may or may not receive a certified copy of sale deed and evidence. It is discretionary in nature only because a document is admissible in nature, as would appear from the discussion made herein above. The same by itself would not mean that the contents thereof stand proved.
Yes.
Then I'll refer to para 35. A registered document in terms of section 51A of the Act may carry therewith a presumption of genuineness. Such a presumption, therefore, is rebuttable. Raising a presumption, therefore, does not amount to proof. It only shifts the burden of proof against whom the presumption operates for disproving it. Only if the presumption is not rebutted by discharging the burden, the court may act on the basis of such presumption. Even when, in terms of the Evidence Act, a provision has been made that the court shall presume a fact, the same by itself would not be irrebuttable or conclusive. The genuineness of a transaction can always fall for adjudication if any question is raised in that behalf. And lastly, para 38 as well. Para 38. In relation to the argument pertaining to section 13(5) of the Food Adulteration Act, a constitution bench of this court and so stated as follows: that the subsection clearly makes the contents of the report of public analyst admissible in evidence, and the prosecution cannot fail solely on the ground that the public analyst has not been examined in this case. But what value is to be attached to such report must necessarily be for the court to consider and decide. And in the facts of this case, what was held, kindly have para 40. Having settled the scope of section 51 of the LA Act as stated herein above, we will consider the facts in civil appeal number so-and-so. In this appeal, originally the land acquisition officer awarded 3707 per acre for the acquired land. On reference being made by the claimant, the reference court enhanced the said compensation to rupees 8,000 per acre, which was challenged by the beneficiary of the acquisition before the High Court. In a writ petition which was allowed, and the matter was remanded back for fresh disposal to the reference court. Before the reference court, the respondent herein produced two certified copies of two sale transactions which were marked as exhibits P1 and P2. The reference court, however, refused to place reliance on the said documents on the ground that the contents of the said documents were not proved. Hence it rejected the reference. Being aggrieved by the said order, the respondent claimants preferred an appeal before the Honourable High Court. The High Court, disagreeing with the reference, relied on the contents of Exhibit P1 and P2 and enhanced the compensation to 15,000 per acre. While doing so, the High Court proceeded merely on the contents of Exhibit P1 and P2 and did not take into consideration the other evidence available on record in regard to the comparative nature of the land, location of the land, the market potentiality of the land, etc., and fixed the compensation on an arithmetic calculation based on the value found in Exhibits P1 and P2. We do not think that this is a correct approach. While it is true that contents of Exhibit P1 and P2 should be looked into as evidence produced by a party, the evaluation of such evidence should be made taking into consideration other evidence if available on record, like other sale transactions that may be produced, the comparative nature of the location, suitability, marketability, etc., to fix the market value of the land acquired. Since such a comparative examination of the evidence has not been made by the High Court in the above appeal, even though there was material available on record, we think it proper that the impugned judgment in the above appeal be set aside and the matter be remanded to the High Court for consideration in accordance with law laid down and directions given in the above case. So in this case, certified copies, cases which deeds which were registered before the registrar were placed and the court accepted being binding. Even here in this case, the court held that that cannot be completely binding on the court. Court may have to look at other evidence as well. Now, again on this point, Veloz, why I'm saying that it is necessary for the court to examine the document by itself.
Yes.
I would submit that in the facts of the present case, the unregistered sale deeds do not have any legal effect. They cannot be recognized at all. Merely because it has been marked as an evidence does not give it any form of legitimacy. Courts will have to see whether it really has any effect on the property which is comprised in those sale deeds. So for that, I'll refer to section 49 of the Registration Act. So there is no quarrel with the fact that as far as a sale deed for an immovable property is concerned,
I think you better give them, or they have the bag.
Gotcha.
Sometimes you don't have the bag here, so at least you can get the bag ready. Yes.
Section 49,
right?
49.
Yes.
So there is no dispute about the fact that in the case of transaction relating to transfer of an immovable property above 100 rupees, registration is compulsory under Section 17.
Yes.
Now, what would be the effect of non-registration is contained under Section 49. Effect of non-registration of documents required to be registered. No document required by Section 15 or any other provisions of the TP Act to be registered shall affect any immovable property comprised therein. I'll skip B and C, and then it reads, unless it has been registered. Now, what would be the meaning of affect any immovable property? That would mean, it has no effect really. That property still remains in the name of the original vendor or the seller. There is no real recognition of transfer of title. The title will still remain with that person legally.
See proviso?
Yes, my lord. So that is on the question of collateral transaction. I'll address that issue as well. What this says is provided that an unregistered document affect an immovable property and required by this Act or the TP Act to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act, or as evidence of any collateral transaction not required to be effected by a registered document. So they have advanced the argument that the sale component mentioned in the sale deeds can constitute a collateral purpose. I'll take your lordships through that. So I'll just conclude this issue that courts could not have attached any importance to this document, number one, because it had no legal efficacy whatsoever. And it has already been held that it is entirely for the court to decide whether any value should be attached to those documents or not. Merely because it has been marked as an exhibit does not mean it has to be accepted as binding. Now, what is also important to note, my lord, is that for the purpose of Exhibit 4, 5 and 6, neither the vendor nor the vendee were ever brought before the court. This dispensation is available statutorily only under 51A and only in cases of certified copies of documents. not for unregistered documents.
Yes.
This would in a sense contradict my argument because I'm already saying that it has no real effect, it has no legal recognition. But even assuming for a moment, the court would have to examine it, it would be for the claimants to bring the vendor and vendee to prove that document. What they did instead, they brought the village head, who was neither an authority on registration of properties, nor an authority on the market value of properties in that area.
Why you say that?
So how can he be treated as an authority for registration, my lords? Registration, the only authority is the sub-registrar.
Having some knowledge about the value of the land area?
I don't think he has shown any knowledge with regard. If we go through his evidence, my lord, we would see that no such knowledge has been shown by him. All he said, I recall that this was signed by these two parties. As far as market value of the other properties in the surrounding area, there is no evidence whatsoever. Except one of the witnesses. He says, I recall that in this particular area, this was the value.
Yes.
That's all. Now, I'm saying he's not an authority by any, who has been vested with that power by any statute. So, the absence of the vendor and vendee and their examination is a relevant factor, my lord. And also, lordships have already noticed that there were visible interpolations in those documents with regard to the price as well as the area. If just to refresh your lordship's memory on that, kindly have the additional paper book. The sale deeds are at page 68 onwards.
Yes.
Kindly see the first one.
Page 68.
68 notes. This is a document dated 5th March 1993.
Yes.
Your lordships will find the last paragraph. The area has been inserted.
Yes.
And there is visible interpolation with the amount.
Yes.
Perhaps would have been some other amount and some other figure has been sought to be inserted here.
Yes.
Similarly, if your lordships have page 72,
This is exhibit 4.
my lord.
This is exhibit 4.
Yes.
Yes. Yes, what did you say about exhibit 4? I mean, this
The interpolation.
five.
Evidence.
Yes.
Exhibit 4, you lords will find two interpolations. Then kindly
Where is
see
that?
page 72.
One
My
second,
lord.
where interpolation, which is
At page 68. In fact, lordships had observed it on the last occasion.
no 68. Yes, that we've seen.
Kindly.
That we've seen with regard to the
5th March 93 document.
yes, that area. Yes.
The
area and the
and the
amount.
price.
Yes, and what about this?
And then
exhibit
kindly
five?
see page 72.
Exhibit, yes.
This is
With
exhibit
interpolation.
6.
Here's just typed.
My lord? No, it's not a typed document.
Exhibit
At
five.
page 72, this is a handwritten document.
No, no.
Not 5, my lords. Exhibit 6 at page 72.
Yeah, this is handwritten.
Handwritten document. Kindly see there is an interpolation here as well.
Area.
With that area 5250.
Yes.
The third thing is the deposition of the village head. All three of them have given identical statements before the court. Their statements are at page 1 onwards.
Just me mark this. One second. So when I refer later on, I won't lose my way.
Lordship.
Page 68 onwards. Yes. Now
Then
to
I'll take your
deposition
Lordships to the deposition at page 1.
of the number 1 paper book.
No, it's on the additional paper book.
Yes.
Well, this is the deposition
On
of,
affidavit.
yes, well, of Leonis R. Linkoy, witness number 69.
Yes, he's CW 69.
69.
Okay. Yes.
This reads that I was the headman of village so-and-so, Umroi, Riboy district from 1990 to 2005. In that capacity, I used to witness the sale deed executed in my village. I am shown the sale deed dated 5th March 93, executed between Ka Aimons 10 and Ka Sildon Lingua, and in respect of land measuring 5453 square foot situated in the village so-and-so, which was sold for rupees 8 lakhs. The buyer and seller of the said land appeared before me, and they have signed in my presence, and I recognize their signature. And I have also put my signature with seal as of having witnessed the sale deed. In our area, as per customary practice prevailing, there is no system of registration of sale deed. The aforesaid sale deed is already exhibited as common exhibit 4. Exhibit 4.1 is my signature. Exhibit 4.2 and 4.3 are the signature of the seller and buyer respectively, who have put their signatures in my presence. So ideally under section 67 of the Indian Evidence Act, the signatures of the parties also have to be proof. So due care has been taken where this person who acts as a witness claims and recognizes their signature in respect of a document which was executed in 93. Remarkable memory, my lord.
Mm-hmm. Okay.
Then kindly see
Further
the second statement at page 4.
Yes, page 1. CW 70.
Yes, my lords. Owendro Kharpan.
How many witnesses do you have, General, at that time? How many witnesses did you take to the before the SGO? Claimant witnesses, how many were there?
Claimants,
Witnesses, claimant witnesses.
they also deposed with regard to
How many were there?
around
100.
total 75. Total 75.
witnesses.
75.
Okay, yes.
75.
Lord. At page 4,
Yes.
this is the statement of Owendro Kharpan. Para 1, this reads, I was the headman of village Pinloon Umroi, Riboy district from 89 to 2000, and in that capacity I used to witness the sale deed executed in my village. I am shown the sale deed dated 21st September 1994 executed between so-and-so and so-and-so in respect of land measuring 4550 square foot situated village Pilloon, which was sold at 7 lakh 50. The buyer and seller of the said land appeared before me and they have signed in my presence, and I recognize his signature, and I've also put my signature with seal of having witnessed the said sale deed. The secretary of the village was also witnessed the sale deed and put his signature. In our area, as per customary practice prevailing, there is no system of registration of sale deed. The aforesaid sale deed is already exhibited as common exhibit 5. Exhibit 5.1 is my signature, 5.2, 5.3 are the signatures of the seller and buyer respectively. So again, this is an identical statement in respect of a different property by a different headman. Then kindly see the third statement at para 7.
Page 7.
Page 7.
CW 71.
CW 71, Poland Malay. And just before that, Lordships will kindly have page 6. This is the cross of the previous witness. Kindly see the last paragraph. A question was put to him whether he knew the market value. He said, I do not know the exact prevailing market value of the land situated in Pilloon area where I am the headman at that time. It is a fact that Exhibit 5 is not a registered sale deed. Then coming to page 7, the statement of witness number 71. I was the headman of village Jao Padongsheng Umroy Ribhoy district from 91 to 2004, and in that capacity I used to witness the sale deed executed in my village. I am shown the sale deed dated 12th February 94 executed between Ka, Bistimai Rongang and so in respect of land measuring 5250 square foot situated at so village, which was sold for rupees 650 lakhs. The buyer and seller of the land, said land appeared before me and have signed in my presence, and I recognize the signature, and I also put my signature with seal as having witnessed the said sale deed. In our area, as per customary practice prevailing, there is no system of registration of sale deed, and then he goes on to identify the respective signatures. All of them have remarkable memory with regard to documents and the signatures of these vendors and vendees, which have been done at least more than a decade, 2 decades back. So these would be relevant factors for the court to consider, notwithstanding the fact that these documents have no legal value whatsoever. There's another point which is relevant, Vinod, is that these documents do not evidence any transfer of money. The passing of the consideration has not been indicated anywhere. This is also a relevant factor.
Yes.
And this has so been held in the judgment of 1996, 10 SEC 37.
Yes.
So on the issue of proof of passing of consideration, I'm referring to this 9610 SEC, page 37.
This will be proof consideration, proof of
passing of consideration.
Nineteen 1996, 10. Para?
Relevant paras, para 2.
Yes.
In para 2, I'm referring to one passage, my lord. It is the 11th line from where that first paragraph ends. It begins with obvious, therefore. 11th line from the bottom.
From the bottom.
From the bottom of the first paragraph.
Bottom first paragraph is para 2.
From the bottom of that first paragraph of para 2. 11th line from the bottom.
Yes, obvious therefore.
Lordship.
Yes. Yes, can you read?
Obvious, therefore, none of the persons connected with the documents has been examined. There is no proof of passing of consideration thereunder or the circumstances in which the documents came to be executed. Under these circumstances, all the documents are inadmissible in evidence and cannot be looked into.
So you see the manner of execution now.
Lordship, everything, if you look at the totality of the circumstances, number one, my first and primary issue is that these documents are not registered, so therefore they have no value whatsoever.
The question is that it already admitted to evidence.
Yes, there I'm drawing a distinction that by itself will not mean that it is binding on the court.
Exactly, but the thing is that this point says that there's no proof of passing or consideration. So under these circumstances, all documents are inadmissible evidence.
Inadmissible.
Yes.
Because where is the proof? The court has to be completely satisfied that this is not a fictitious sale.
Yes.
So, my lords, the court has rightly rejected or discarded these documents. It has given its own reasons. It has also said that there is no way to understand what is the classification of that property and whether it can be compared to any of the lands which are sought to be acquired by the state. So, there were various reasons that the court indicated for discarding those documents. Now, the next issue, my lords, is with regard to that collateral purpose. It has been argued by my learned senior that even assuming that these documents are unregistered and inadmissible, they can be looked into for a collateral purpose. And the further argument is that this price or the consideration mentioned in these sale deeds, Exhibit 4, 5 and 6, would constitute a collateral purpose. So, according to them, price mentioned in a sale deed is a collateral purpose.
Yes.
So Lordship had also posed a question that day, what would be a collateral purpose in this particular context? So this test has been laid out by the Honorable Supreme Court. May I just refer to that, my lords? 2008 8 SEC. Sam? Yes, I've given that.
You fresh list of dates today?
Yes, my lord.
Yes, a list of
2008 8 SEC 564.
564.
Yes, ये compilation में भी reference है उसका KP Shah का.
उनको मन पे जो नहीं.
So as the relevant paragraph is para 34 at page 577.
Okay. Yes.
So we'll kindly have that para page 577, para 34. So the court surveyed various decisions of the Supreme Court as well as other courts. If your lordships have it.
Para 34. Is it from the principles?
From the principles, my lord.
Yes.
This is the test that has been laid down. From the principles laid down in the various decisions of this court and the high courts, as referred to herein above, it is evident that a document required to be registered, if unregistered, is not admissible into evidence under Section 49 of the Registration Act. Such unregistered document can, however, be used as an evidence of collateral purpose as provided in the proviso to Section 49 of the Registration Act. Now, this is important, Lord. A collateral transaction must be independent of or divisible from the transaction to effect which the law required registration. A collateral transaction must be a transaction not itself required to be effected by a registered document, that is, a transaction creating, etc., any right, title, or interest in immovable property of the value of 100 rupees and upwards. If a document is inadmissible in evidence for want of registration, none of its terms can be admitted in evidence, and that to use a document for the purpose of proving an important clause would not be using it as a collateral purpose. Now, I'm concerned with the test number 3 and 4, my lords, that whether the sale component is independent or divisible from the main transaction. That is what your lordships will have to examine. So for that, if I may take lordships to the Transfer of Property Act, the definition of sale contained under Section 54.
How much is covering today?
I'll conclude, my lord. So this is the second last point. Just 2 more points. Take another 10-15 minutes, my lord. So I'm referring to Section 54, my lords, the definition of sale. It reads, sale is transfer of ownership in exchange for a price paid or promised or part paid and part promised. So therefore, what is intrinsic is that transfer of property to constitute a sale, there must be an exchange only for a price paid. By definition.
Yes.
So in case there is no price component, then it can't be a sale. If there is a simpliciter transaction, conveyance of property, it could constitute a gift. But for it to constitute and qualify as a sale, there has to be a price component, which is in exchange or in lieu of the transfer of the property. Now the next question is, what happens in case there is no price component featuring in the sale deed? What would be the effect? Because here I'm referring to a decision of 2021 SEC Online 1097.
10?
1097. 2021 SCC Keval Krishna. So I'm referring to para 16 and 17.
Yes.
At internal page 5.
16.
16, 17, internal page 5. So, well, it's para 16 refers to the definition of sale. I'll just skip that since I've read it already. I'll refer to para 17. Hence, a sale of an immovable property has to be for a price. The price may be payable in future. It may be partly paid and the remaining price can be made payable in future. The payment of price is an essential part of a sale covered by section 54 of the TP Act. If a sale deed in respect of an immovable property is executed without payment of price, and if it does not provide for the payment of a price at a future date, it is not a sale at all in the eyes of law. It is of no legal effect. Therefore, such a sale will be void. It will not affect the transfer of the immovable property. So, applying the test laid down in Kebisha, it means that unless and until the collateral purpose is divisible or can exist independently, it cannot be termed as a collateral purpose. So, the price component is an integral and indivisible part of the sale. So, therefore, it cannot constitute by any measure a collateral purpose, my lord.
Okay.
This is the next decision I'm relying on is 2023. Paul Rubble. So I'll refer to para 12 onwards at internal page 9. So Paul Rubber Industries versus Amit Chand Mithun, 23 SSC.
Yes.
Lordship. Internal page 9, para 12.
The same view.
Yes, ma'am. I'll read this. The same view was broadly reflected in the case of so-and-so. Section 107 of the 1882 Act, which we have quoted above, stipulates that a lease of immovable property from year to year or any term exceeding 1 year can be made only by a registered instrument, so far as section 106 of the said statute is concerned, in which distinction is made between lease of immovable property for agricultural or manufacturing purpose and lease of immovable property for any purpose. The same provides that a lease of immovable property for agricultural or manufacturing purpose shall be deemed to be a lease from year to year terminable by 6 months notice. In other cases, termination would require 15 days notice. The subject agreement had a duration of 5 years with a provision for renewal for a further period of 5 years. Hence, under the first part of section 107, for the said lease agreement to be admissible, registration of the same would have been necessary. The deeming provision of subsection 1 of section 106, so far as the same related to lease for agriculture or manufacturing purpose, would not be applicable as the deed was not registered. The appellant has argued that the trial court had admitted the lease agreement in evidence, and for determining the purpose of lease, we can examine the deed. But this argument is flawed. This provision contemplates lease for manufacturing purpose in absence of contract or local law to the contrary shall be deemed to be a year-to-year lease. In that case, it would require 6 months notice for termination. But here, the agreement itself provides a 5-year duration and hence, ex facie becomes a document that requires compulsory registration. That is the mandate of section 107 of the 1882 Act and section 17 and 49 of the 1908 Act. Though court cannot admit it in evidence as per the judgment of the case in so-and-so. A quoted bench in the case of Shyam Narayan Prasad versus so-and-so has reaffirmed this view, referring to section 49 of the Registration Act. This is a prohibition for the court to implement, and even if the trial court has taken it in evidence, the same cannot confer legitimacy to that document for being taken as evidence at the appellate stage. The parties cannot by implied consent confer upon such document its admissibility. Then kindly turn to the next page, page 11, para 14. On behalf of the appellant, however, it was argued, referring to the provisions of Section 49 of the Registration Act, that for establishing nature and purpose of possession, even an unregistered document could be looked into, as that would come within the ambit of collateral purpose. On this point, judgment of this court in so-and-so case has been relied upon. In the case of Sevok Properties, a coordinate bench opined that as the agreement for lease in that case was unregistered, contents of the instrument were inadmissible in evidence. There was admission in the written statement of respondent in the case of Sevok Properties by the defendants that they were in occupation under the lease agreement in controversy in that case for a period of 15 years with effect from so-and-so, and that period of lease had expired on so-and-so. The issue decided in that case was whether the lease stood determined by efflux of time, and once it did, what would be the position of the lessee. The coordinate bench found that the position of the lessee would be that of a tenant at sufferance. In that context, it was held that there was no necessity to terminate the lease under Section 106 of the 1882 Act. That case was decided on the basis of admission in the written statement and has no application to the facts of the present case. The observations made in the case of Sevok Properties, that only purpose for which the lease can be looked at for assessing nature and character of the properties was in that context, and that judgment proceeded on the basis that the period of lease had expired on a certain date. This decision is not an authority for the proposition that nature and character of possession in an unregistered deed could always constitute collateral purpose, so that court could examine the deed for that reason. The purpose for which lease is granted forms an integral part of the lease deed in this case, and this very issue forms one of the main disputes. The expression collateral purpose has been employed in proviso to Section 49 of the Registration Act to imply that content of such document can be used for purpose other than for which it was executed or entered into by the parties, or for a purpose remote to the main transaction. This view was taken by this court in an earlier decision in the case of KB Shah. Then they reproduced Section 34 of the judgment in KB Shah. I'll just skip that, my lord. I'll come to para 15. In the case of Raichand Jain versus so-and-so, dispute arose as to whether certain premises were let out for residential purpose, or as to whether there was an oral agreement for letting out the premises to the tenant for running a press. It was in that perspective it was held that in the said case that a lease deed though unregistered, could be considered for collateral purpose to show the purpose for which the premises was leased out. Thus, the lease deed was referred to for the sole purpose to defeat the claims of subsistence of an oral agreement. The ratio of this authority has been considered in the case of KB Shah, and we follow that ratio. In the case of Satish Chandra Makhan, another coordinate bench of this court declined to accept admissibility of an unregistered lease agreement for determining duration of the lease, 9 years in that case, on the reasoning that terms of lease would not constitute collateral purpose. It was observed in this judgment that nature and character of possession could constitute collateral purpose, but that would not be the point which was directly in list before this court. In our opinion, nature and character of possession contained in a flawed document being unregistered in terms of Section 107 of the Act and Section 17 and 14 of the Registration Act can form collateral purpose when the nature and character of possession is not the main term of the lease and does not constitute the main dispute for adjudication by the court. In this case, the nature and character of possession constitutes the primary dispute, and hence court is excluded by law from examining the unregistered deed for that purpose. In respect of the suit out of which the appeal arises, purpose of lease is the main list, not a collateral incident. So applying this test, again, we would see that the reason why the unregistered sale deeds were sought to be relied on was to refer to the price component therein. Now, first we have to see whether the price component can be divided or can stand as divisible or as independent from the main deed. So I've just referred to the definition of sale. It cannot. It is an integral, intrinsic and indivisible part of sale. And insofar as this case is concerned, it is the most important subject matter for adjudication by this court. So therefore the courts would be excluded from looking into the price component by virtue of the decision in Paul Rubber.
Next point.
Next one is the last issue. This is something which refers to their compensation for certain other losses.
Interest?
No, that we've already covered.
Oh, yes.
One of them was in the case of Armstrong CM. He had prayed for compensation for damage to fencing in Iron Gate. Now, my argument here, my lords, is that, and this is also connected to that first argument which relates to how a reference proceeding is based. It's entirely based on the objections contained in the reference application. And that is the starting point of a reference proceeding. So, our case is that the reference court derives jurisdiction to decide a reference only on the basis of what is referred to it. So in case certain issues are not referred to the court or certain parties are not referred to the court, the reference court would not have any jurisdiction.
Outside the purview.
Yes, my lords. Only the terms of reference are to be decided by the court. Now in this case, kindly have paper book 1. It's the reference application is at page 96.
Yes.
So the relevant part is in the typed copy at page 97A. So the purpose of taking your lordships through this document is to ascertain what was the grievance or what was the objection taken by the claimants.
97A.
97A. It's a typed copy.
Okay. Yes.
So I'll read from para 3 on para 3 onwards. This reads.
Yes, read.
That the petitioner's landowners state that during the process of making declaration under Section 6 of the LA Act, from the date the notification under Section 4 was issued, there was substantial damage to the land and crops of the various landowners, and no payment for such damages was made to any of the landowners as is provided under Section 5 of the LA Act. The petitioner landowner states that without taking any actual and physical measurement and without classifying the categories of land and without assessing the value of the standing crops, trees and other cultivations, the petitioner's landowners were made to sign on certain forms, and the representative of the landowners filed a writ petition in the Honorable Guwahati High Court, Shillong Bench, and the Honorable High Court, by order dated 14/11/2002, directed the collector to proceed with the acquisition proceedings in accordance with the provisions of the Act as amended, to intimate the concerned landowners about the measurement and classification of the land as contemplated under Section 9, to allow the concerned landowners to kindly skip one page and come to the typed copy minutes at 98A.
Yes.
To receive the compensation awarded in accordance with the first proviso of clause 2 of 31. It was also directed that the collector shall not take into consideration into acceptance of statement made by any landowner before him on 17-18 October 2002 in tempest of the notice under Section 9 of the LA Act. The directions of the Honorable High Court were duly conveyed to the Honorable Collector for necessary compliance. That the petitioners state that no demarcation of the land of the landowners was made by the collector, and two boundary pillars of the landowners were fixed, and no measurement of the land was physically taken by the collector. The land was also not classified. No assessment of the standing trees or crops or any other cultivation was made as was mandatorily required under Section 8 of the LA Act, and no landowner was informed about the measurement, classification, etc. of the land as was required to be done by the related law, as well as the order dated 14/11/2002 passed by the Honorable High Court. The petitioner landowner states that without complying with the requirement of Section 8 and of the order dated so-and-so of the Honorable High Court, the Honorable Collector purportedly prepared the map and the plan relating to the land and issued notification number so-and-so dated 29/11/2002, asking the landowners to appear on 16/12/2002 at 11 a.m. and file their objections. The notification was purported to be a notification under Section 9 of the LA Act, but the said notice was not in accordance with the requirement of law, inasmuch as the particulars of the land of the individual landowners were not specified and the individual landowners were not even informed about the actual measurement, classification, etc. of the land. Then kindly skip one page to the typed copy at 99A. This reads that the petitioner states that on receipt of the general notification dated 29/11/2002, the petitioners filed objections dated 14/11/2002 as regards the measurement, classification of the land and the proposed rates for the various categories of land. Pursuant to the objections raised about the measurement of the land, the collector it should be issued, issued the notice number so and so.
It should be
Vide the notice number so and so dated 10/1/2003, informing the landowners that the EAC revenue along with the SDO PWD will come to measure the land from 21/2003 to 28/1/2003 at different villages, but no person in reality came for measurement. The landowners lodged an objection dated 28/1/2003. That the petitioner landowner states that no inquiry was conducted by the collectors as regards the actual area of the individual landowners, demarcation of boundaries, assessment of land and its categorization. No village record relating to the price of land were checked. The records of the Land Revenue Department sub-registrar of the office of the collector were also not verified, and the price of the land per square meters of different categories were also not intimated. And without complying the requirements of law and the order of the Honorable High Court, the collector made an award on 7/7/2003 and issued notice without specifying the area of the land and the price of the land of the individual owners. The notices specifies only the amount and they do not specify the basis on which the amount is arrived at. The notices under Section 12(2) of the LA Act were signed on different dates commencing from so on and so forth. Then I'll skip to that. Kindly see the prayer at page 100. So your lordships will see from the pleadings, there is no mention of anything apart from classification of land and the amount and the measurement. They repeatedly mention three things.
Section 8.
Alert?
That regarding Section 8, they mentioned it.
No, I'm saying here, the grievance is limited to the measurement of the land, the classification of the land and the price. And they've made a passing mention about the trees and the crops.
The prayer, you mean?
Yes. Now, no, I'm saying the contents of this entire document. Those are the 4 issues that they've raised. In the prayer, at page 100, Lordship will find, in the premises, therefore, pray that the Honour would be pleased to make a reference to the Special Judicial Office of Meghalaya for determination of the actual measurement of the land, classification of the land, demarcation of boundaries, market price of the land and building, standing crops, trees, cultivations, etc., and allow the landowners, petitioners to withdraw the amount. So this was the prayer. But if you look at the entire pleadings, the pleadings are only limited to the market value, classification and demarcation of the land, the measurement, and loss to the cultivation and the trees. On the basis of this, a reference was made.
So you say market value, measurement value, and classification.
Yes, that is all that they had raised in the reference application.
Yes.
Now, if your lordships will see the reference order at page 108. This is the reference order dated 31st October 2003. So, if your lordships will see serial number 9, nature of objections taken to the award and what has been recorded by the collector for determination of the measurement, classification and the rate of the land in the locality. Now, rightly or wrongly, this is what the terms of the reference were.
Are they just nature objections or terms of reference? Is there any difference between them? Nature objections given by them.
So objections are what are taken in this.
Will constitute the reference.
Yes, my lord. Objections are what are contained in the Section 18 application.
Okay. These are the terms, you mean?
And these are the terms. So the special court is now invested with jurisdiction to decide only what is referred to it.
Okay.
Now, what the court has done has gone beyond, because during the course of the trial, they've raised several other issues. For instance, in one of the cases, Armstrong CM has raised losses with regard to his iron fence, his gate and so on, and he's produced documentary evidence, and court has granted that. Now let us see whether that is permissible. I'm referring to a judgment of 2003 5 SCC. Prayag Upnivesh. Prayag Upnivesh, 2003 5 SCC.
Page?
The relevant page, my lord, is
561.
561 is the page, and page 565 is the relevant page, para 7 onwards. Para 565, page 565, para 7 onwards. It is well established that the reference court gets jurisdiction only if the matter is referred to it under section 18 or 30 of the Act by the land acquisition officer, and that the civil court has got the jurisdiction and authority only to decide the objections referred to it. The reference court cannot widen the scope of its jurisdiction or decide matters which are not referred to it. The question was considered by various judicial authorities, and one of the earliest decisions reported on this point is so-and-so. This was a case where the claimant sought a reference under section 18 of the Act. In the application filed by the claimant, he raised objection only regarding the valuation of the land. The claimant did not dispute the measurements of the land given in the award. Both the reference court, the claimant raised objections regarding the measurement of the land and sought for fresh measurements. This was refused, and the claimant applied to the High Court for revision of this order, but without success. Again in the appeal, the claimant raised the same objection regarding measurement, and the High Court rejected it. The Judicial Committee of Privy Council held thus: their lordships have no doubt that the jurisdiction of the courts under this Act is a special one and is strictly limited by the terms of these sections. It only arises when a specific objection has been taken to the collector's award, and it is confined to a consideration of that objection. Once, therefore, it is ascertained that the only objection taken is to amount of compensation, that alone is the matter referred, and the court has no power.
This is the basis of
My
the
lord, and the
argument.
court has no power to define or consider anything beyond it.
Important judgment.
My lord. The next, my lord, para 9.
Yes.
In so-and-so, the land acquisition officer made a reference under section 30 for apportionment of the compensation amount amongst the various claimants. 6 of the appellants did not accept the award of the land acquisition officer and made application to him for referring the matter for determination by the court, but no reference was made by him pursuant to this application. When the matter came up before the court, it proceeded on the footing that the reference made to it was not merely limited to the apportionment of compensation, but also with respect to the amount of compensation. No objection, however, was raised by the state before the reference court regarding the absence of reference. When the matter came before the High Court, the government pleader raised this objection. Though the High Court allowed the plea to be raised before it, but ultimately it negatived the plea. The appellants contended before the High Court that pursuant to the failure of the state to raise the plea before the subordinate judge as to the absence of a reference, the state must be deemed to have waived this point. Rejecting this contention, this court held, the matter goes to the court only upon a reference made by the collector. It is only after such reference is made that the court is empowered to determine the objections made by the claimant to the award. Section 21 restricts the scope of proceedings before the court to consideration of the contentions of the persons affected by the objection. These provisions thus leave no doubt that the jurisdiction of the court arises solely on the basis of the reference made to it. No doubt the land acquisition officer has made a reference under section 30 of the Land Acquisition Act, but the reference was only with regard to the apportionment of the compensation amongst the various claimants. Such a reference would certainly not invest the court with the jurisdiction to consider a matter not directly connected with it. This is really not a mere technicality, for as pointed out by the Privy Council and so, whenever jurisdiction is given by a statute, and such jurisdiction is only given upon certain specified terms contained therein, it is a universal principle that those terms should be complied with in order to create and raise the jurisdiction, and if they are not complied with, the jurisdiction does not arise. This was therefore a case of lack of inherent jurisdiction and the failure of the state to object to the proceedings before the court on the ground of an absence of reference insofar as the determination of compensation was concerned cannot amount to waiver or acquiescence. Indeed, when there is an absence of inherent jurisdiction, the defect cannot be waived, nor can be cured by acquiescence. In a recent decision of this court and so, it was held that the reference court has no power to convert the reference under section 30 into one under section 18 of the Act at the instance of those who did not apply for reference. In the instant case, there was no reference by the SLAO under section 18 of the Act, and the appellant so was not before the SLAO. Even the application allegedly filed on so was rightly been characterized as suspicious, as no mention has been made by the SLAO in the reference letter dated so. In the absence of a proper reference, the additional district judge has no jurisdiction to decide the question of enhancement of compensation. When such an objection was not referred to the court, there was complete lack of jurisdiction. So therefore, I was referring to the reference order as well as their application under section 18. So now we would have to decide whether the court has exceeded its jurisdiction. So grant of any form of compensation, which was never raised,
over and above the terms
was
of
beyond.
reference.
So I realize that this was never raised at the stage of trial, but this judgment takes care of that. It holds that this would be a case of lack of inherent jurisdiction.
1 second. Yes.
So I would conclude with this, will it? I think my learned senior will take at least a day or two.
Lordship, I just
You give the date, Mr. General.
I'll give just where is the folder?
But this decision is very revealing. You know, grant of compensation over and above terms of reference is without jurisdiction. That is very telling. Yes.
For this point, Your Lordship, I'll just show page number 97
of
first paper book.
But
I'll page 9, no, before.
Here I've seen second paragraph. That's what I was indicating to Mr. Sen, that the precious landowners state that during the process of making declaration of Section 6 of the Act, from the date notification of Section 4 is issued, the substantial damage to land and crops.
Yes, land and crops.
That's been noted. Who has noted that?
No,
he has said that. But he has said that reference be limited
Lordship,
only to objections raised by the landowners.
Let's see what is referred. Page 107.
Yes.
This is the reference order. With reference to the above, Lordship got it?
Yes.
Page 107. With reference to the above, I have the honor to forward herewith an application under Section 18 of the LA Act, filed jointly by one Shri Armstrong same of so and 67 other. Having perused the application, I am to make the following observation. That part 1 of the application claiming to have been made by 137 landowner is not supported by facts on record. That out of total of 67 so. Now, what Your Lordship, I am trying to the last para, the application under Section 18 of the LA Acquisition Act is accordingly enclosed herewith for favor of kind necessary action and disposal of your end.
Yes.
Now, by this application, whatever I have stated in my
reference
petition that was referred.
No,
my learned friend has read only the page number 108.
Nature objections taking the award.
He has only referred to page 108.
May I point out why?
and
this is, my lord, a forwarding letter.
Forwarding letter.
This is not the order.
Forwarding letter states what? That I have filed an application under Section 18. Now, collector has not done anything on that application. He forwarded that application to the special judicial officer for determination and for determination.
We'll argue that, yes. Anyway, when?
Your Lordship will just give me
1 day.
Hardly 1 to 2 hours maximum. 10th or 11th, any date. Or 8th, 8th I will not be possible. 10th and 11th, any date. Or we keep it on both the date.
Keep it on 10th, you can spill over to 11th, but we'll conclude it.
10th.
Like 10th.
Lordship.
Oh, let's go for the hearing on 10th for reply by the claimants. Yes.
Item 13.
This is that pension, my lord, the other petitioner was claiming for a pension of, claiming herself to be the wife, my lord.
Where's
and
Mr. Deb?
Mr. Deb, yes, my
Where's
lord.
he?
Was in around. Because he was absent on 6th June also, and thereafter on the request, this matter was fixed today.
He came that day, we were not here.
My lord.
But he didn't make any submission.
My lord. So, my lord, I would pray, my lord, this matter deserves to be dismissed.
Let him be here.
Because my lord,
He was to be allowed continuance in his absence.
My lord.
I'll list it next week.
Next week, my lord. Next week, I'll join online, my lord. Obliged.
As the council petitioners are present, this is the matter next week.
All right. He has come.
Where were you? If you're here, I didn't see you, yes. What do you want to say? Can't show us.
Lordship, on last occasion, they said that there's some loan pending which has taken by my late husband. So, Lordship, here, Lordship, the issue is only to the extent that I'm challenging the...
Now the thing is that, okay, fine. He wants to confine it to that. He said, forget about the loan, forget about the burden. The only thing is that I'm challenging it on the ground of the illegality or legality of the order passed by the council court, when in this case, your prayer was allowed.
Yes.
That's the only thing.
Yes.
And from there, you're still interested in pursuing that?
Lordship,
if that goes back, you're putting yourself to again, why does this court shortcut a process that to avoid you going through the entire process again? And you put a legal aid, correct?
Yes, my lord, it's legal aid.
Lordship, if they are giving me some reasonable amount, Lordship,
They already give you, how much you will give the 1 lakh?
My lord, we said 50,000.
Yes.
And then they wanted more, 50% of whatever this thing.
50% you take up the debts also.
Yes.
So if you want, how much more do you want?
Lordship, a reasonable amount, Lordship.
This
Because,
amount,
Lordship,
okay.
my children are unemployed, Lordship. I do not have any house.
Okay. The burden you have to pay is 4.5 lakhs of the loan your husband took.
Yes.
So that means you have to pay him only 1.5 lakhs now.
And moreover, Lordship, they have already received some benefits, Lordship. They have already received.
You're precluded from arguing that because you said I'm not going to go there. I want to argue that the miscase. That was the last time we fixed it in today.
Lordship.
That the order passed, but the judge, the council is wrong. That's what. That's all he said. That in the miscase, he was declared the legally wedded wife, right? But court doesn't want to put you two widows into this court system again.
Yes.
So as a council now, you understand that whether you want to put them to that agony again.
Lordship, I may be allowed an opportunity, Lordship, to establish that I am the legal wife. Because, Lordship, I was the first wife, Lordship. I was the first wife. Only my...
I'm not interested in that. Court's not interested in that. Court says shortcutting the whole process. It's been lingering long enough.
Yes. And because of which, my lord, the pension, though I and my children are nominee,
yes,
the pension has been withheld, my lord.
The only thing is that they say that they were not heard when the matter was taken up by the council court.
My lord, even if what
They were heard also will not serve any purpose.
my lord, even if that happens, even if it goes back, my lord, what will be the end result? Because
Exactly.
the nominee
That
is
is why
me.
Mr. Dempsey,
Yes.
he knows that the back is to the wall.
Yes.
That is why he's saying now he wants to go back there.
Yes.
Now courts examined, we've heard you countless times. Then, why you put that person to agony? Just, it's for ego or for what?
Lordship, the fact is that
Person's dead. When did he die?
he died, I think,
It's a
Lordship,
long time back.
Long time back.
Yes, long time back, my
18,
lord.
Lordship, 2018, I think. Lordship.
So take what little amount and just go on with your life. Enough.
Yes.
There's no sense in relegating it back.
We have been generous. We are saying that I am also a widow without any work. I'm saying in spite of that, see, now I have to pay 9 lakhs to the bank with interest, and above that I'm saying that okay, I'll pay you 50,000, and she has survived. She is working. She is surviving. Her children are all adults now. None of them are minor, my lord. Even if there's a minor, we will share, but none of them are minor. So a poor lady is been so generous, my lord. Even when she knows that she is the nominee, legally entitled, even if declared not to be a legal wife, just assuming without admitting, still then I'll have a more status of.
So
receiving
we'll
the
do one
pension.
thing. We'll dismiss your case then.
Yes, my lord. Yes.
We'll pass orders.
My lord. Yes. Obliged.
No, we'll pass it. We'll pass in your presence, so you won't be aggrieved, because you don't have registered marriage also.
Lordship.
They have a marriage certificate.
Yes, my lord.
Her name
Lordship, I have
appears
very
in the-
limited submission. Lordship, I started cohabitation with my husband since 1992, and they have started cohabitation. They have made it, Lordship, in the year 2000. So, Lordship, during the period of 8 years, Lordship, that was long enough, Lordship, cohabitation. So, according to Lordship, the customary.
That's why they
law-
give you 50,000 rupees.
So, Lordship, being a first
You
wife,
take
Lordship,
that money and run. Otherwise,
Lordship, I am the first wife, Lordship.
only thing is that you're not heard. That's the only thing you have with you, nothing else. No document. You brought nothing here, and even in the civilian application, nothing is this. Only your assertion.
Lordship, even Lordship, in my identity card, in my all documents, my husband's name is there. In my birth certificate of my
Okay, you
children,
do one
my
thing. Yes.
husband name is there.
We will not stop the pension to them.
Yes, madam.
Take it back to the council.
Yes.
With one date of hearing. Enough.
Yes, my lord. But
Yes.
that pension should not be stopped,
No,
my
no
lord.
stop. Yes.
Yes, my lord. Oh.
Take down. Might as well dispose it off. If you insisted on that,
Yes.
otherwise we thought it takes some money. Court was being kind. So
Yes.
anyway, the petitioner being aggrieved with order dated 2020, passed in Miss Case number 1 of 2020 by the Court of the Judge, this is Council Court, Hills, Shillong, has preferred the instant civil revision application. Under 227? It's under 227.
This is my lord.
Under-
Yes.
Yes, sir. Yes, Lordship.
It's under Article 227.
227.
Under Article 227, where is your petition?
226, yes, mentioned, my lord. An application under section 226.
How be 226?
227. 227.
Under Article
Order 6.
227.
Order 6.
Under 227, under Order 6 of the High Court of Meghalaya, bracket, jurisdiction of the Council, Courts, close bracket, Order 2014, read with Article 227, Constitution of India. Stop. The main ground for challenge is that the petitioner, the brief facts are that the petitioner claims to be the wife of one late, within bracket, late Carlos CRLUS Lamin Gayang, who had expired on 5/5/2019. And at the time of his death, he was retired or he was still serving?
He was serving.
Was serving in the office of the Directorate of Information and Public Relations. Stop. the petitioner, this has been submitted that the petitioner had then approached the said respondent for disbursement of family pension and other benefits. However, the petitioner was then informed that she was to obtain an order from a competent civil court having jurisdiction to show that she was the legally wedded wife of the deceased employee. Stop. It appears that you didn't go and file.
No, Lordship.
Yes. The petitioner thereafter came to learn that by order dated 20 on February 2020, passed by the impugned order dated 2020, the learned judge, the council court declared the respondent as the legally married wife of late Carlos Lamin Gayan. Next paragraph. Mr. B. Deb, learned counsel petitioner, has submitted that the writ petitioner was never made a party before the proceedings, in the proceeding before the district council court, and that the declaration given to the respondent by the said court is illegal and in violation of the principles of natural justice. He therefore prays that the order be set aside and the matter be remanded back for reconsideration. Next paragraph. Mr. P. Ubin, the counsel for the respondent, has submitted that the petitioner has not been able to bring before the court any evidence or instance to show that she was ever legally married to the deceased employee, but that, however, the respondent, as can be seen from the impugned order, had produced all the required necessary testimonials, that is such as marriage certificate, nomination in the service book, right?
Yes.
Nomination service book, as also the birth certificates of the children from the said wedlock. Then the council submits that the widow is saddled with the responsibility saddled with the debts and securities of the his employee amounting to amount of rupees 9 lakhs.
9 lakhs, my lord.
Which he has to discharge. Notwithstanding the hardship faced, he submits the respondent to close the matter is willing to offer the petition 50,000 as a closure. He further submits that relegation of the matter back to the district council court will cause unnecessary harassment to both the parties. So I therefore praise that the impugned order be upheld, inasmuch as be upheld, and the revision be dismissed. Yes. And further, that the responsible willing to give the petitioner 50,000. I've heard the counsel for the parties. On a second query from the court to Mr. Deb, it appears that the stand of the petitioner is adamant, and the prayer is reiterated that the petitioner be allowed to prove her case that she is a legally married wife of the deceased employee. Stop. Next part. This court notes with some regret that though the materials that have been placed for the court do not show any matter that will deserve any further consideration, in spite of the fact that the petition was not heard before the court of the judge, this council court. However, an insistence of the petitioner, and in view of the fact that it is correct that she was not made party before the court of the judge's council court, this matter shall stand remanded back to the court of the judge, the council court, for consideration. Stop. Next part. In order to shorten the process, the court of the judge is expected to dispose of the matter preferably within a period of 2 months thereafter, after remand. So, next paragraph. Records given. Yes, the records are be transmitted immediately to the court of the to the lower court, and further on receipt thereof, the said court shall record the petitioner as a party respondent, Stop. Next paragraph. Further provided that the parties are put to notice to appear when before the court. To appear today is the
5th, my lord.
To appear on 22nd.
22nd, my lord.
22nd July before the court at 10:30 a.m.
My lord, may kindly note also that about the pensionary, because
yes,
that's
with regard to the prayer for
release of the family
release of pension, as a situation, are you being paid now? No.
No, nothing, my lord.
Then can you order that now?
Because of this, because what is saying that we'll see the outcome of the High Court. So that is only, though there was no stay.
Be within 2 months then.
2 months, my lord. But otherwise, what is happening, my lord? Then again, this loan interest.
We understand.
Yes, my lord.
You put respond to grieve injustice, Mr. Deb. You should advise your client. But if your insistence, court cannot force you to come to any kind of settlement. But we kept the matter pending for so long because you have no materials to show you ever married. You were cohabiting maybe for 5-6 years. Then he entered into a valid marriage with the respondent. It was registered. Then children were there. The names and service book.
Even lordship, I also having children, lordship, from the same.
But how old are your children now?
Lordship,
they are all adult.
All adult.
Then
I think
like still depending on you for support.
In the meantime,
that's not an excuse.
My lord, if that will oblige, my lord, will be obliged, my lord. In the meantime, that if my lord directed, they should not come as an because
the dependency
act
of
as per the
of this proceedings shall not stand.
Yes.
It shall not stand in the view of the authorities determining no, you won't add that. I'll correct the order.
My lord.
But it'll create more problems for them.
My lord. Obliged.
15.
Lordship, just recently we received 30 crores. That will be able to clear up for 4 months, Lordship.
Pension or salary?
For both, Lordship. Because
Not,
for a month, Lordship, we are paying all about 7 crores, Lordship.
Now we are left with 12 months, my lord. What they have received is 30 crores, my lord, and it seems the salary plus pension they have to pay around 7 crores. So if
you take the entire money, also no development, nothing for the Salary of the other staff, anything?
No, my lord. What I'm saying is that pension and salary comes to around 7 crores. So as per the submission, they're paying us 4 months. So it comes to around 28 crores, my lord. Another 2 crores is left. They can clear the pension, my lord, with that.
We can't direct that.
My lord, let them take instruction, my
Let's
lord,
close
because
it now. You pay them and we'll close it for a time being.
Lordship, because
yes,
these are
submits that a certain amount of money to receive.
My lord, if your lordship close it right now.
We won't close it. Okay. List it after now you.
Because Lordship, these are
how the
yes,
money
will
will
be
be
take
dispersed.
instruction on that. Yes.
Because these are ongoing Lordship. Whatever we get.
So I should pay you.
Lordship.
Contempt, may I pray, Your Lordship, that the contempt may be closed, Your Lordship.
Contempt against whom?
No, now.
That is the salary.
The chief secretary and also the.
Yes, you're a contempt. There's no willful violation, Mr.
Lordship,
Because now what is happening in the ground level, my lord. Now 13 months we are not being paid a salary, and it's not only affecting us, but it's affecting our duty, my lord. Now district council is playing a very important role of looking after lands. We have to go to the spot for land holding and everything. That is being affected. Not only that, my lord, but the staff is also discharging. Some of the staff are discharging judicial duty, my lord. Process server are not being able.
We are well aware of that. That is why we even want to move that. We want to possible the state they have apportion a special budget only for judicial for the judiciary.
If this contempt is closed, my lord, then everything will be kept in cold storage. Now things moving.
Contempt is what, Mr. Shilla?
I understand.
Contempt is not something to twist someone's arm doing.
No,
Contempt is that you just bring notice of the court whether there's any violation. If the court sees no violation, that circumstances prevent some authority from doing it, then there's no contempt.
No, my lord, because
there have been cases where the notice of contempt been sent. One of Supreme Court is said punished for contempt. What can we do?
Because
even if we punish for contempt, we think they'll cough up that money.
Because my lord, as per the direction, preferably within 6 months they have to release the amount, my lord. Nothing was done. It's only after.
Even the order sometimes, but is it willful?
No, because what's appearing, my lord, after we file it, then only things are moving, which appears there's some willful. The fact that they're not doing anything, my lord. It's only after this contempt is being filed, then 30 crores are coming up. Now how many crores are still there? We don't know. The district council are not paying us.
Okay, let's have to 2 weeks. Yes, no, 3 weeks then.
Lordship, in my humble and respectful submission, Your Lordship, there can be no contempt against the officer of the state.
There can't be no contempt, and we'll leave it like that. You're not issue notice of contempt.
Lordship.
But contempt, Mr. Shilla, contempt has to be in the face, of the violation is in the face of the orders of the court.
I'll try to satisfy this court next time.
That's in the face of the order of the court.
18.
Yes.
So this is a case that Afroza Begum, she's asking for the salary. The case filed with the prayer that the prayer is that to release the salary of the prisoner with effect from May 21 till date. There was a case.
He is not sanctioned teacher.
He's a sanctioned teacher.
Desanctioned.
No, now there's no such order passed by the government. He's not a sanctioned teacher. Now, in this case, many affidavits filed by the government. The first affidavit which was filed by the government, which is filed by the government on, it is signed by one Victor Somstars Nongbet.
Who's that?
How it has come? पेपर था तो कहाँ गया? पेपर था.
Yes. Subtly. We'll have it at 2 o'clock.
Yes, ma'am. Lordship, some other day.
Why?
Just a week time.
Why?
Some personal difficulties.
What was the difficulty? After lunch, you can't open your mouth anymore.
No, I can come. Just possible for the day only.
Is it fair, Mr. Okay, possibility? The rest doesn't matter. 2 o'clock is.
Monday will take up.
Yes. Yes.
If Lordship, kindly allow me to. Lordship, there is one item number.
I don't understand why there's a mental block against 2 o'clock hearings.
Lordship, I have some personal difficulty. Matter can be taken up on Tuesday, Your Lordship.
I know personal difficulty is mental block after 2 o'clock.
Your Lordship. I have some personal difficulty.
Maybe we need to do a little bit of recalibration.
Of Your Lordship.
We'll do one thing.
On
Next we'll change it. We take up hearings in the morning and motions at 2. Then I think there won't be any mental block.
Let it be on 9, Your Lordship. On 9, certainly I'll do it, Your Lordship, if my friend is...
Which matter?
I'll do. Item 25. Item 25, Your Lordship.
Which matter?
Promotion.
Okay, on 9.
On
yes,
9.
The rest of the matter at 2 o'clock? The rest of...
2 o'clock.
26 matter for the university.
26 which matter?
Tuesday. 26. I'm appearing for the university, Your Lordship.
What's the matter about?
This might not use SCP, MSCP.
Yes, Your Lordship.
If Lordship
I'm appearing for UGC in this matter, my lord. 26.
Your Lordship accommodates me. Some accommodation I'll say, Your Lordship. It can be taken up after
1 week, okay.
2 weeks. 2 weeks.
You're there in the case?
Yes, I'm for the petitioner.
I'm for the respondent number 2.
Okay, very good. 2 weeks, yes.
All right.
Yes.
Bless.
Yes. Absolutely.
May I please, Your Lordship?
Yes. At 2 o'clock we'll take it up. Yes?
Item number 20, Lordship.
We'll take it up at second half.
Your Lordship,
Lordship, I think Mr. Paul is also not there.
Lordship, both of the councils they communicated in the morning that they'll be praying for some time, Your Lordship.
You're also not well?
I'm not well, Your Lordship.
Oh, when then?
Next week?
Next after 1 week. 20
Lordship,
after 1 week, okay.
Lordship, we are having our
Vacation.
summer vacation. Yes. Lordship, can it be taken on 22 or 24, any day?
Okay.
I need to come personally.
24, yes. Okay, yeah. Please come. You are finished with the matter.
Yes, that day. Yes.
What's left?
Your Lordship, item 27 as well, Mr. Thapa, he's having some difficulty.
Yes, okay.
Madam, I'm for the state, for the MECL Corporation respondent, madam.
I'm for the state.
I'm for the private respondent.
2 weeks.
Madam, 2 weeks.
Highly obliged.
Friday, Friday, what do you call it? 30. Yes,
30.
Yes?
30.
30, Sophia Nongsiej. You want to do it?
Yes, sir.
Who's other side? Yes, Ayn.
I'm appearing for that.
Lordship, can it be on 22 or 24?
Yes, yes, you'll get your date. Yes.
Yes, that's highly obliged, Lordship.
Yes. Yes,
Yes, my lord, I'm ready.
she's ready. We take her about 2 o'clock, or you'll do it now. How long will it take?
My lord, just few submissions, my lord, not much.
Yes.
So,
I can
may
find.
it please your lordship? My lordship.
One second, let the file come.
Yes, my lord.
Sure. Take it. Give her. But you want to go for lunch? No problem. Court should sit till 4:30, so no problem. Yes. Yes.
Your Honor, if I mean, my lord, if
continue,
it's-
yes. Okay, start.
May it
Since
please-
you're the only last case left. Yes.
Yes. May it please your lordship. Your lordship, the petitioner has applied for the post of counsellor issued by respondent number 1, which is at page number 9 and extra 1.
Page number 9. Counselor, where in?
Post of counsellor. In Office of District Social Welfare Officer, West Khasi Hills, Nongstoin.
Okay.
Serial number 3, my lord. Counsellor.
Okay, 18 to 32 years. Okay.
The petitioner has also given the written examination, Vide Annexure 3, page 13, my lord. The petitioner has secured the second highest mark to the said post in the written examination, my lord. Annexure 3, page 13, my lord.
How do you know?
Roll number is there. My roll number is 019. 019. Yes.
Okay.
I have secured the second highest mark, my lord. It is a fact that the candidate who secured the highest mark, my lord, in the written examination has not come for the interview. Thereby, the petitioner is the top scorer at the time of the interview.
Okay.
My lord, when the final results were declared, which is at page 4, my lord, annexure 15.
Sorry, it's all right. Take your time. No problem, yes. Now, what happened?
My lord, when the final results were declared, which is at annexure 4, page 15, my lord, the appointment of the post councillor to the respondent was given to respondent number 2. The respondent number 1 has appointed respondent number 2 for the said post of councillor, my lord.
Kelba Mary Nongrom.
Yes, my lord.
Okay.
Now the respondent has also filed an affidavit and brought on record the mark sheet prepared by DSC, my lord, which is in the reply, the rejoinder filed by the state, my lord, which is at annexure 1, my lord.
Affidavit of opposition?
Yes, my lord. Affidavit in opposition in reply in the writ petition on behalf of respondent number 1, my lord.
That's at page 11?
Yes, my lord. Page 11, annexure 1.
Okay.
My lord, I have also filed my rejoinder. My lord, the challenge...
Okay, one second. Now, you are...
Sufiano
number 3.
Yes, my lord.
Number 3, okay, number 3. The other one scored 93.2.
Yes.
What is the component of Viva?
My lord, the component of Viva here is 60 marks, my lord.
60 marks. Where did you get it from?
My lord, the chairperson has written here CWC 60 marks, GGB member 60 marks, DCPO 60 marks.
Okay, yes, okay.
And then an average is calculated, which
my
is
lord, let me complete my submissions, my lord.
Okay, yes.
Yes, my lord. The challenge in this writ petition is the selection of respondent number 2, my lord, to the post of councillor. The advertisement, my lord, which has been advertised by respondent number 1 is nowhere mentioned, my lord, the process of selection. It consists of 2 tiers. That is the written and the interview, my lord. And my lord, my other point is that it is nowhere
why
mentioned.
you not mentioned, you mean? Where's the advertisement?
My lord, advertisement, it is in my petition, my lord, in the petition.
You've seen that. It says that the
departmental
section SUS invites applications legit candidates who are on purely contractual basis. Contractual basis?
Yes, my lord.
In the district child years.
Yes, my lord. It is nowhere mentioned, my lord, that the 2 tiers consist of written and the interview, my lord. And it is also nowhere mentioned that the selection is based upon the consolidated marks.
The selection was based on consolidated marks because written and interview has to be there.
But it has to be mentioned, my lord. This is a public advertisement, my lord. It has to be clearly mentioned.
But one thing you have to understand,
yes,
if you had any quarrel with the advertisement, then you should have
challenged the advertisement.
Challenge at that point of time.
But my lord...
So now, once you've taken part selection, you can't turn around and do it.
My lord, my humble submission is that, my lord, I am not challenging the advertisement here for the reason being, I am challenging the way, the process they recruited respondent number 2, my lord.
No, once you've taken part, no matter, you can't challenge selection process anymore. Simple as that.
But
court would like to help you if there's any patent illegality. There's nothing. Once you've gone by advertisement, you've taken part, and then the selection, they've produced the marks, they've shown that, they've shown that the other candidate got more than you, then nothing remains.
But my lord, kindly hear me, my lord. On
I'm
few
hearing
grounds,
you. Yes.
On few grounds also, my lord.
Yes.
There is no relevant rules in the affidavit, my lord, which is filed by respondent number 1 to declare that the selection is based on consolidated marks. And the respondent number 1...
Once you've taken part, suppose you had a grouse, then you should have said, no, what is this? Like, why before the selection, when you call, where's the call letter calling you where's the call letter asking you to come sit to examination?
My lord, this is at annexure 3, my lord.
Calling you for examination.
My lord, yes, this...
No. Calling you. You must have gone pursuant to some notice.
Yes, my lord. These serial number are qualified to appear for the personal interview.
No. First written.
Yes,
right?
yes, my lord.
Where is that note? Where is that call letter you got for written?
Page 12, my lord. Annexure 2.
Yes.
Yes, my
Then
lord.
why didn't you object that time?
But my lord, I am here challenging the process of which the recruitment done to respondent
I'll
number
give
2,
you
my
a
lord.
judgment. The judgment was saying, Iran. Ketua anda ada judgment apa tak di bank. You do one thing. I'll send the judgment. You take it my PS from the room. Okay. Then you read the judgment and then you come and argue it again.
Okay.
But that's settled law. Okay. I don't want to dispute. Otherwise, there's no case. You read the judgment, and in that judgment, they've digested a lot of judgments about what happens when candidates come. Even though there might be some discrepancy in the selection process, also there might be some anomaly. But once you've accepted, you've sat for the examinations, then you have to accept it. You accepted that, you have to accept it. Anyway, I'll pass on the judgment.
Highly obliged, my lord.
Yes.
A pleasure.